interactive panel, so those participants don't sit back and wait to listen in. Right from the point go, you're going to be part of the panel. So unlike other panels that have had 3 to 4 people, this one is going to be a full house panel. Prepare for that. And kindly don't run away because you've been co-opted to be part of this panel. I'm quite a gracious man. I won't harass you beyond what you can't handle.
Curious to know because with the headphones, do you need the headphones?
Everyone's speaking the show is panel, right?
Yeah.
Oh, okay. So it's all a bit different. How come you remember? And I wasn't even presenting that. So that's nice. Thanks. Yeah, this was a very nice. Excited about this brave judge who had issued a warrant for arrest. And I'm very worried about South Africa, which is on the shelf. And in your country,
But have you seen these litigations against the government to ensure that they do execute the warrant? So
that's not bring the judge. That's very interesting.
well, you've got a very big
Cape Town said they didn't stand with the mayor there.
of course the mayor will say that. First of all, the African obviously you're not in time in much of the court. I understand that because it's
Even for us, it's pretty over.
sure, and the political issues are presenting is going to seriously affect our economy from the greatest point of view as well as the financial now is talking to the board. So what it's going to our position internationally. The International Court of Justice, we are a member, but we don't used to execute. I think that's the freedom of expression.
This is the book that been read. Sure, so it's not.
Ladies and gentlemen, just confirming a good morning to you all once again. You're welcome for this panel where we come to talk freedom of expression, digital rights, trends on the globe, trends in the region, and definitely we are going to hear in from you on trends in your countries. Cerebral Alpha is my name, and I'm privileged to be moderating this panel. One of our panelists is online, connecting in from the US. So you will bear with her. I don't think she had a night's sleep, but well, she is here with us. I take the honor and the privilege of inviting our panelists. First of all, allow me to introduce Florence, who is joining online. Florence Nakaziwe, yeah, she's right there. And she is a senior legal advisor on the Sub-Saharan Africa panel, working with ICNL. She is responsible for providing technical assistance and advice to governments, civil society organizations, and regional institutions in Africa on civil society law reform. Florence contributes to ICNL's research on civic space within Africa, and she also contributes to the monitoring of emerging trends and assessing the legal and environment for civil society to inform ICNL's program. Previously, Florence worked as a legal officer at the UN Office of the High Commissioner for Human Rights in Uganda for 9 years, where she primarily advised and directed the supported legislative development. She is a member of the Ugandan Bar, where she has served on the Uganda Law Society Legislation Committee for 2 executive terms. She also forms part of the East African Law Society Regional Board. Florence, we are glad to have you.
Thank you very much, Arthur. It's a pleasure to join you today.
Lovely. On the extreme end, we have Joyce. Joyce Odua. And Joyce has almost a whole thesis of bio. So I will brief it. You want to find that bio, you may need to go to the Palu website. It is actually 6 pages. And now this is the brief version. Joyce is a managing partner of Joyce and Okay Odua Law Practice, a full-service commercial law firm situated in Lagos State in Nigeria. In 1990, she obtained a Bachelor's of Laws degree from the University of Lagos, and she was called to the Nigerian Bar in 1991. Kindly don't pull out your phones to start calculating how young she is. She is currently the Vice President of West Africa for Palu. Can we clap for that? Yes, she's our Vice President. Madam Vice President, we are privileged to have you. I told you hers is a very long one. She has under her belt a number of national and state appointments, including a board member of the Gurara Water Management Authority, Law Reform and Administration of Justice Reform Committee, the Upper Ibono State, the Lagos State Blueprint Committee on the Administration of Justice. I told you it is what? It is a thesis. And she is the president and founder of Fountain of Life for the Needy, a non-government organization aimed at providing for the needs of the indigent women, children, youth in Nigeria. I'll skip to the last line. Joyce is married to Mr. Okay Odua, a lawyer, and she is blessed with 4 children. I could not leave that out. And then we are joined by Professor Joseph Kachungu Yav, full professor of law at the Faculty of Law, University of Lubumbashi in the DRC Congo. He holds a doctorate of law from the University of Lubumbashi in DRC, a master's degree in human rights and democratization of Africa from the University of Pretoria, a master's of law from the University of Lubumbashi, a diploma in transactional justice, another long thesis of bio. He is the managing partner of Yav and Associates, a law firm that is based in the DRC, where he practices as an attorney of law, and he has been doing this for more than 20 years. He worked as the executive director of the Center for Human Rights, Democracy, and Transitional Justice, and the coordinator of the UNESCO Chair for Human Rights, Governance, Conflict Resolution, and Peace at the University of Lubumbashi. Joyce and Prof, we are glad to have you part of this panel. And then comes me. My bio is just 1 line. The Chief Executive Director of the Network of Public Interest Lawyers in Uganda, a network that pulls together over 157 members, individuals, law firms, and organizations that are pursuing strategic litigation in Uganda, and I'm honored to be a part of this. Good. As we go through this panel discussion, somebody may wonder, what has freedom of expression got to do with sovereign debt? And this is where you come in as participants from this panel. How many of our country constitutions guarantee the freedom of expression? If your country does, let's kindly raise your I want to see the white, not the hand. Something white that you have. Fact check. My country guarantees freedom of expression. Okay, great. Despite the guarantees, my country also restricts freedom of expression. Fact check. Great. I have been at data before. Kindly raise your hand if you have been at data before. You're data. Somebody's data. Don't worry, it's a safe space. Raise your hand. How many of us agree that datas actually have rights? Datas have rights.
Especially.
Datas have rights. Good. Who of us has been in a situation where you are a data to a data? You are a data to a data. Great. We have a hand over there. I don't know whether you can kindly put on your microphone and share your experience of being a data to a data. I saw your hand behind there. Is it possible? Which rights did you enjoy and which ones didn't you enjoy? Very critical place to be, being a data's data. As datas, do we ever have freedom of expression when it comes to engaging with our creditors? And how freely do we enjoy that freedom of expression? Well, Africa is in that place where we are datas to others, but also our governments are datas, and we are datas to our governments. And that's why we come to look at the trends of freedom of expression, digital rights in this era. And to kickstart this discussion is Florence. Florence, as I said, works with ICNL. And Florence, we are here to listen in. What are the trends like? What is actually happening to matters freedom of expression, digital rights at the globe and then at the regional? Over to you, Florence.
Thank you very much, Arthur, for that introduction. Again, good morning, ladies and gentlemen. I'm honored to be a part of this panel of esteemed speakers and senior colleagues, reflecting on the trends around freedom of expression and digital rights in Africa during this ongoing summit or annual conference for the Pan-African Lawyers Union. And as you rightly noted, issues of freedom of expression have an intersection with the theme of the conference, which is data, or date rather. Why? Because these are decisions that impact on the democratic states where we are citizens. And because we have leaders who are accountable to us, we need to be able, as civil society, to exercise oversight over the decision-making processes, because this touches on issues of resource management of public resources, which will also impact directly at the individual level. The escalation of debt will also impact on individuals because obviously the government will be taking measures against your financial capacities to be able to pay back that debt. And so your ability to speak out when things go wrong and exercise checks and balances on the state is part of thriving in a democratic system. I will go straight into providing some of the trends that we have seen to kickstart this discussion. I need to share my screen because I have a PowerPoint, but it's showing me that only one participant can share at a time. I don't know if I'm able to. I will try again and see if it's. I will need to be authorized, Mr. Moderator, to share my screen and project my PowerPoint.
A thumbs up to you. You can go right ahead.
I think IT might have to help me because it's not allowing me to.
Sorry about that. At the time when you're talking about.
Okay, now I'm good. Now I'm good. Can you see?
Yes. Not well. Yes.
Perfect.
You can, okay, good. Yes, I will go. So for the benefit of everyone in the room, as I've been introduced, I'm Florence Nakazibwe. I'm a senior legal advisor on the Africa program at the International Center for Not-for-Profit Law, ICNL. We are based in Washington, DC. ICNL is an international organization that works to promote an enabling legal environment for civil society and the media. We do this through monitoring and tracking legislative developments that impact on civil society, as well as measures that would affect the ability of civil society to operate and influence on public issues. So through our monitoring and tracking, this slide shows the global trajectory of what we are seeing in terms of the measures that governments are imposing that impact on civic space. This is a global trajectory that covers over the last 5 years, from 2018 to date, which shows that a lot of the measures that governments are introducing impact mostly from a restrictive perspective, civil society's ability to operate. 84 countries that we have monitored across the world have proposed or enacted at least 288 initiatives that impact on civic space since 2018. This is globally, and of these, only 17% of those measures are enabling, and I will address which aspects are enabling and which aspects are restrictive. Again, from our monitoring tracker, we have also seen that over 73 countries in the past 5 years globally have proposed and enacted 239 legal measures that again restrict civic space. When you see this global map, of course, you will see the Western Hemisphere. This has covered 10 countries. In Sub-Saharan Africa, which is the largest, where we see a lot of these restrictive measures, in over 28 countries. In Sub-Saharan Africa, in Europe, where we have seen at least 3 countries, in Eurasia, where we have seen 6 countries, in the East Asian Pacific region, where 13 countries have introduced these restrictive measures. When it comes to Sub-Saharan Africa, which is where my program focuses, again, we have seen in the past 5 years, at least 30 countries in the region have proposed or enacted restrictive legislation, 88%, which is the majority, and then only 12% have been enabling. A grand total that we have seen is 119 measures. All these measures, as you can see, the state is increasingly using the law as a weapon to restrict civic space. And this is why, as lawyers, obviously, these are issues that are pertinent to our role and work as lawyers. Now, where are these being reflected? Where are the legal restrictions manifesting? Before we go to the Sub-Saharan region, I will start off with the global region, or the global, the geographical, worldwide. A significant amount of these legal initiatives impacting on civic space relate to what we call life cycle laws. Life cycle laws are those that regulate civil society establishment, operation, and dissolution, which is the full life cycle. A lot of measures that we see are governments imposing restrictions on CSO's ability to operate or even to register and formalize their status. The second category of restrictions that follows after life cycle restrictions is expression, which is 20%. Again, here we have seen 47 measures in the last 5 years that have been adopted that impact significantly on civil society freedom of expression, which is the topic of our discussion today. Counter-terrorism and anti-money laundering laws are also the third in line when we see restrictive legal measures that governments are increasingly adopting worldwide. And fourth, we are also seeing surveillance and measures that are restricting the right to privacy as the fourth initiative through which governments are restricting civic space. And the fifth category is cybercrime laws, which again, I'm sure many of us would have some specific examples at the country level, how this is manifesting. So these are the top 5 measures that we see governments are introducing to restrict civic space globally. Of course, we also have disinformation, which is also very close in line to these other major trends. At the sub-Saharan African level, which as I indicated is where my program reflects, again we are seeing similar trends as what we are seeing globally. 34% of the legal measures that governments are imposing are relating to life cycle laws. Again, like I mentioned, laws that are restricting civil society or NGOs' ability to register, to operate, and to voluntarily dissolve their operations. The second set of restrictions we are seeing increasingly is 30% relating to expression. So as you see, restrictions on freedom of expression are quite high-handed, as we are seeing across the region. And then, of course, you have counter-terrorism and anti-money laundering laws as the third category through which states are imposing restrictions at different country level. We also see surveillance, which is another high-handed trend. 9% of the countries that we have monitored have also imposed restrictions on through surveillance laws and right to privacy restrictions. And then fifth, we are also seeing cybercrime laws. And lastly, which I quote here, is around disinformation frameworks. In terms of, again, the global trajectory that we see, again, similar to what we have seen since the past 5 years, in the last 2 years, we have seen, again, around the same percentage of restrictions globally on freedom, on civil freedoms generally. 83% measures that governments have imposed globally are restrictive of civic space, and only 17%, as we see, are enabling. A lot of these enabling frameworks relate to, for instance, access to information laws. We have seen data protection laws. We have seen some reforms around penal code frameworks, which again remove criminal sanctions such as defamation offenses. We see replacing criminal defamation with civil defamation. So we are seeing some level of enabling frameworks, but a significant chunk of the measures that governments are imposing are highly restrictive, including in the last 2 years. Coming to the sub-Saharan region, in the last 2 years, again, we have seen a total of 19% enabling frameworks. This is 7 frameworks that we have seen in the region, and a significant part, which is, we are glad to say, has shown a slight decrease in the restrictive measures that we are seeing in the region. In the last 5 years, it was 83, but in the last 2 years, we have only recorded 81%, so 2% reduction so far. And these measures of restrictions that we are seeing have largely, again, been around issues of freedom of expression, anti-money laundering and countering terrorism laws, as well as surveillance and the right to privacy restrictions. Going into the specific trends, how is this manifesting? What are the trends that we are seeing affecting freedom of expression and digital rights in the region specifically? One, starting off on digital. As we have seen an increasing closing of civic space offline, civil society have now increasingly embraced digital platforms as forums that enable the exercise of their human rights online. As civil society increasingly use these platforms, we are also seeing that the governments are asserting more tightened control on CSO's ability to use these platforms. The 5 main ways that we are seeing these restrictions manifesting are through digital surveillance. We are seeing disinformation frameworks, internet shutdowns as another growing trend. We are seeing the use of restrictive legislation on freedom of expression and other fundamental freedoms, and also the practice of arresting and charging individuals who are exercising their speech online. To break it down, one of the threats that we see affecting freedom of expression is the rising digital authoritarianism. This is the repressive and pervasive use of digital technologies by governments who are cooperating with corporate entities to use digital technologies to surveil on individuals. As an example, we have had examples of the NCO Group's Pegasus software, which was used to target journalists and activists around the world, including in some sub-Saharan African states. Some examples that have been reported globally are Uganda, Ghana, Kenya, Togo, among others. These surveillance technologies have been utilized by security, law enforcement, and intelligence agencies who continue to use it without transparency. And we are also seeing the lack of policy frameworks and regulation of the use of artificial intelligence, which are, again, tools that security officials are using as part of their protection of national security. This is already presenting severe risks to the safety of human rights defenders, to media and civil society practitioners. We have also seen that increasingly in many states, there has been a building of capacity for mass surveillance and interception of communications using malware and intelligence network monitoring systems, which again lack adequate oversight, including the courts providing oversight on how these tools are utilized. A lot of these telecommunication tools have obviously been imported from countries such as China and Israel, among others, and are rapidly being deployed across the region, as I indicated, mostly deployed by security agencies. And so it's critical as civil society to keep up to date in terms of the legal basis in which these tools are utilized that does not interfere with the right to freedom of expression. Again, we are also seeing restrictions on online speech using cybercrime legislation. In 2002 alone, we have recorded at least 10 measures that have been introduced in the region by countries. An example that I can highlight is Kenya, where they have introduced and proposed an Information and Communications Amendment Bill that imposes restrictions on the improper use of telecommunications systems. Again, very broad and vague restrictions on individuals' right to exercise their freedom of expression online. In Kenya, again, as well as in Uganda, we have also seen the use of the computer misuse and cybercrime laws, again targeting political opponents. We have seen also human rights defenders, as well as rights activists. In Kenya, in Tanzania, where we have seen the electronic and postal communications online content regulation, among others. We have also seen the taxing of social media platforms, as well as registration requirements, which again continue to impose restrictions on individuals' ability to exercise freedom of expression online. Internet shutdowns is another contentious issue that we have seen in the region, primarily during elections, where states have imposed it in the guise of protecting national security. The level at which these internet shutdowns have been imposed has been highly arbitrary, and we are happy to see that lawyers have taken up actively to challenge these measures in courts of law, primarily because a lot of these shutdowns are not regulated clearly in any legal framework. And this trend has actually been recorded by Access Now, which runs a Keep It On campaign that highlights that there has been growing trend of shutting down the internet in many countries during elections and also during protests. Running quickly, we have also seen blocking of social media sites. A good example we saw in Nigeria, where the Twitter was banned in 2021, and it lasted for 7 months, and later, of course, it was opened up. In Uganda, we saw the closing of Facebook from the 2021 elections until now. So we are seeing arbitrary closure of social media sites. Moving on, we are again, like I indicated, we are seeing the use of securitized measures under the guise of combating anti-money laundering and financing of terrorism. The use of these laws we have seen in over 40% of the countries.
In 2 minutes.
Okay.
Thank you.
40% of the countries we working at ICNL, governments have introduced amendments to anti-money laundering laws and countering financing of terrorism laws to impose restrictions on civil society. Since 2002 alone to date, we have seen these measures and amendments reflected in Somalia, in Zimbabwe, in South Africa, in Tanzania, Uganda, Ethiopia, Mozambique, among others. While these anti-money laundering measures can be legitimate, what we are seeing is that states are using them in the pretext of targeting perceived critics. A lot of them have been used inappropriately as measures to implement what we call the Financial Action Task Force standards, which on the other hand actually require states to take a risk-based approach when regulating NPOs or non-profit organizations. What we are seeing instead is that as governments are reforming their anti-money laundering laws, they are instead creating barriers for NGOs to, among others, access resources from different sources of funding, be it domestic and foreign, especially foreign funding. We have also seen the incorrect categorization of CSOs as reporting entities under anti-money laundering laws, which is against the FATF standards. As a good practice, I want to highlight Nigeria has recently reformed its anti-money laundering law and countering financing laws by removing non-profits from the list of designated reporting entities. And so we are hopeful that this would work as a good example for other countries to emulate. Thirdly, as I conclude, we are also seeing expression being stifled through restrictions on peaceful assemblies. We have seen mass protests in several countries across the region, in Eswatini, in Kenya, in Mozambique, in Nigeria, in Senegal, South Africa, and Tunisia. A lot of the participants in these gatherings have been subjected to arrests and excessive use of force by authorities who have also attacked journalists and persons with disabilities, among others. Peaceful assemblies are active voices and avenues through which civil society can express their views on public policy issues. And so the clampdown has also been one way that we are seeing restrictions on freedom of expression. And again, we are seeing a chilling effect on freedom of expression through the broad use of hate speech laws, disinformation, and false news laws. We have seen disinformation laws across the region. The challenge is the way the offenses embedded in these frameworks have been used again to broadly target civil society and the risk that they pose to civil society. We have also seen some good practices across the region. In Malawi, for instance, which last year repealed criminal defamation under the Penal Code, which was reformed, which is a good practice. We are also seeing in Tanzania, where civil society is pushing for the amendment of the Media Services Act, again, to, among others, repeal criminal defamation. Overall, there are more countries in sub-Saharan Africa that still retain criminal defamation in their statute books, and as such, impose restrictions on freedom of expression. And lastly, as a positive trend on issues of freedom of expression, we are seeing that countries are increasingly adopting data protection laws, which provide essential safeguards on the way information that is collected and processed by state agencies, private sector, and civil society is done in compliance with data protection regulations. We have seen at least 30 countries in sub-Saharan Africa introducing data protection and privacy acts. This is actually a positive trend, especially where we are seeing growing surveillance practices in the region. That you can call on government to strengthen some of these mechanisms. In the same laws, again, we are seeing that there are not enough safeguards. We have reviewed a number of laws where we have seen that they have not provided enough safeguards on the protection of data privacy. Sensitive personal data can actually be processed arbitrarily as long as it has been provided publicly, therefore removing the obligation of data processors to protect that information regardless. We are also seeing general exemptions on data protection in the name of protecting national security and public interest, which are again very vague terms that have not been elaborated under these laws, as well as, of course, not providing the judicial oversight when it comes to violations of data privacy.
Thank you so
where
much,
data
Florence.
subjects have been implicated. So again, we are seeing that whereas this is a positive practice to have these data protection frameworks, there are still gaps that will present challenges when it comes to people's individual data and how it can be utilized to infringe on their freedom of expression and civic freedoms. And lastly, just to say again, we are seeing mass data collection systems, the biometric systems that are applicable in different countries, which are actually being used as conditions to access public services, as we have seen the Huduma number in Kenya, we have in Uganda, where again we have the biometric ID systems that are being used as part of the national identification process. This has legitimate purposes. The third trend that we are seeing is how security can actually utilize some of that information to target individuals arbitrarily in the absence of data protection safeguards and mechanisms that oversee how this information is utilized. So overall, those are the key trends that I wanted to highlight for purposes of this discussion. And of course, as part of drawing reflections, of course, I'm looking forward to seeing what does this mean for lawyers. Are we victims, and what role can we play as stakeholders? Are there strategic actions that should be taken in response to these trends? And then highlighting some ideas on what has been effective so far, what strategies have worked best in the region, and where have we failed. Thank you so much, Mr. Moderator.
Thank you so much, Florence. Wow. And Florence, can you take us back to your slide number 6? And friends, sorry, we gave Florence a little more time because ICNL is the sponsor of this panel. They must get value for money. And you never know, they might be the people who flew me in. So he who does work to the piper determines the tune.
Yes.
And friends, when you look at slide number 6,
Yes.
I'm now back to the bigger panel seated on this side. How many of us are saying, my country is not part of what is being reflected on that panel? Okay, how many of us are saying the trend reflected on that slide is true to my country? By show of hands. Some? Okay. How many of us say that in the recent past, my country has suffered internet shutdown? Show of hands. Some people still enjoy internet freely. And how many of us are saying, in the recent past, my country has suffered Facebook shutdown? We only 2 or 3, good. And how many of us are saying, in the recent past, my country has suffered Twitter shutdown? Now, I want to listen in. I know she talked about Kenya, Uganda, Nigeria. Somebody in the larger audience, somebody tell us why the internet shut down, when did it happen, and how was it resolved? From the audience. Anybody willing to share their country experience? Why the shutdown? Yes. Take to the mic. Kindly tell us, when was the shutdown? Why the shutdown? What was the effect of the shutdown? And how was it resolved? You may introduce yourself.
Oui, je suis Christine Kamazai, avocate au barreau de Kinshasa, RDD, RDC, démocratique du Congo. Alors, s'agissant de la fermeture de l'Internet, c'était pour des raisons purement politiques. Et c'est arrivé, je crois, il y a environ 3 ans passés. C'était pour des raisons politiques, comme je le disais. Qu'est-ce qui s'est passé? Il y a des informations qui étaient en train d'être véhiculées sur les réseaux sociaux, lesquelles informations n'était pas bonne pour le pouvoir qui était en place à cette époque-là. Alors, pour éviter que ces informations soient vraiment relayées, le pouvoir en place a pris la décision de faire, et sans informer le peuple, sans informer la population. On se réveille un matin comme ça, on se rend compte que l'Internet ne passait pas, les réseaux sociaux ne passaient pas. Si oui, c'est arrivé à Kinshasa, c'est arrivé en RDC. Alors, on s'est posé la question et on est resté comme ça, je crois, pendant 2 jours. Et c'est seulement après que le gouvernement a pris la parole pour dire effectivement c'est sur base de son ordre que l'Internet était fermé, c'était pour éviter la divulgation de certaines informations. Et nous sommes restés comme ça. Donc, il n'y a pas eu réparation des préjudices, comme le gouvernement est le seul, comment dire, n'a pas une autre institution qui puisse lui faire pression. Et c'est resté comme ça. C'est vrai, la société civile est descendue pour dénoncer cette attitude. Après la dénonciation, rien n'a été fait. Merci beaucoup.
Wow. You might think Florence's entire presentation was on the DRC. That is the trend. Somebody from another experience, shared lived experience from our countries, before I get back to my panel. Another lived experience from our countries before I get back to our panel. Why the shutdown? When was it? What were the implications? Okay, allow me now to turn to Joyce. Joyce, we've had the trends. And definitely we know there are implications, not only for civic space, but also for legal practice. And of course, when we talk of legal practice, we're also talking of civic space. What do these trends mean for a legal practitioner in Africa today? But well aware we are not operating just as a region, but we are operating as a bloc. Over to you, Joyce.
Thank you so much, Otta. Greetings, esteemed colleagues and co-panelists. I would say I'm very happy to be a member of this panel to speak on this very important topic, trends in freedom of expression as it pertains to the rule of law. But first, please permit me to make some points that in respect of what my co-panelist Florence have made. Freedom of expression, like we all know. Can you hear me, please? Thank you. Freedom of expression.
Yes.
Thank you, Florence. Freedom of expression is a fundamental right, enshrined in various international and regional treaties, and in the constitution of most countries worldwide, including my country, Nigeria. I would like to say, for instance, we have Article 19 of the Universal Declaration of Human Rights, Article 19.2, so we have to be very specific on this, of the International Covenant on Civil and Public Rights. Also in other countries, all these our African countries have ratified all this except 2 countries, and those 2 countries is actually Comoros and South Sudan. Yeah, not done this. My presentation will draw more from my country, Nigeria. For example, our own law that protects the freedom of expression is actually in section 39 of the Constitution of the Federal Republic of Nigeria. And what does it say? It says every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impart ideas and information without interference. The question now is there anything in our constitution or other laws that have been brought in that will infringe on these rights that we have? We have one which was promulgated in 2015, and that is the Cybercrime Prohibition and Prevention Act 2015. Also, some provision within this Nigerian cybercrime prohibition and Prevention Act 2015 are overly broad and ambiguous, creating potential opportunities for the curtailment of legal free speech. One of the provisions in the Cybercrime Prohibition Act 2015, Section 24, was intended to curb cyber stalking and false statements online. It says any person who knowingly or intentionally sends a message or other matters by means of computer system or network that A, is grossly offensive, pornographic, of any indecent, obscene, or mesmerizing character or cause at any time, that is sent. B, knows to be false for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, ill will, or needless anxiety to another, or causes such a message to be sent, commit an offense under this act and shall be liable on conviction to what? To a fine of not less than 7 million naira. And that is a huge amount for this. Or imprisonment for a term of 3 years, of to both such fines and imprisonment. Why this? However, the government has abused this provision to impinge on freedom of expression. They can falsely accuse individuals of disseminating false information and impose penalty without merit. For example, we have a case that happened in Cross River. What the journalist did, he wrote about the government and said the governor of the state has taken some money or done some things that he was not supposed to do. He just placed it on the internet. And what happened the next day, they picked him. And he was in prison for a long time just because of this. Until now, the man is still there, Akbar. Is still in prison. So you find out that this is a way of curtailing people's freedom of expression. And that is what brings in the lawyers. What do we as lawyers have to do? What is our role? Our role is to make sure that all these issues are taken to court. We need to take these issues to court and then contest it in court. Because, and also not only contesting, we need the best of judges. Because it's difficult. You might take these cases to court, but what happens? What does the judges do? For example, I will tell you, most of the judges, like in Nigeria, we have an issue. The issue that we have in Nigeria is this, that our judges are not financially independent. And once a judge is not financially independent, what do? You will dance according to the tune played by the governor of the state. What? Because most of the time, they will tell you, if you don't do according to our bidding, what will happen? You won't get maybe the car you're supposed to get maybe after every 4 years. You will not take care of your court. There are a lot of things, money that you need to help the judiciary might not come. So what we need and what we're employing is that we ask the government, and we have been on this for years. Even when I was a general secretary, we went on, and they went on strike and said, we need the independence of the judiciary. So to be able to help us on this freedom of expression, we need the independence of the judiciary and not only lawyers. Before I will now go to the role of the lawyers properly, I would like to come back to what Florence mentioned concerning the Twitter ban in Nigeria. What happened concerning the Twitter ban? The president himself, it was during the time of the campaign or so, the president wrote something on his Twitter page. And what he wrote was, against a section of the country. In Nigeria we have a lot of sections. We have the north, we have the south, we have the east, we have the south. Just mention that a particular section, if they are not careful, what happened during the war, the war of 1967 or so, might happen to them. So because of that, there was outcry in the country. And what did the people say? They started saying, no, the president cannot do this. And the president cannot use the handle of Twitter to do this. And I think they called on Twitter, and Twitter had to pull down. Twitter had to pull down what our president wrote, and our president was annoyed. And it was because of that that the president now banned Twitter. And said, come, there were a lot of excuses given, you don't have the right, what we're doing is secure, this is against our security, the security of our country, why did you pull us down? So they had to ban Twitter. So there was here, there, but Serap had to institute an action. I think in the ECOWAS court, if I'm not mistaken, instituted that action. And the ECOWAS court gave a declaration that what the president did was actually wrong. That the president does not have the right to pull that down because it goes against this section 19 of the African Charter, section 9 of the African Charter, our African Charter, the African Charter on Human and People's Rights, and also it goes against section 19 of the Universal Declaration of Human Rights, and also section 19 of the International Covenant on Civil and Political Rights. So I think later on, Twitter and the government had a meeting, and after some months, Twitter was on again. So that was what really happened. But my own is that, what should we as lawyers do? What should we as lawyers do? What are we lawyers for? Is it just to sit down when this thing happens and just look at it? No. We as lawyers should act as activists. That is our function, and I think that is what we should do with that. We as lawyers, we should act as activists. As legal professionals, we have the power to act as activists and defend the fundamental rights to freedom of expression. The term lactivist, one of our colleagues is not here, he was there at the opening ceremony, he used that word, lactivist. It was introduced by a speaker during the opening ceremony, highlighting our role in challenging any law or practice that violates this right. By utilizing social media platforms, we as lawyers can effectively raise public awareness, advocate for legal reforms, and fight against any unconstitutional limitation on speech. Through mobilizing support, you know, when we come out, when we use the social media platform, we can mobilize support and increase public consciousness. We can make a significant impact of safeguarding freedom of expression. What are we as lawyers? We can act as lawyers, we can be defender of human rights. That is the second one, defender of human rights. The protection of human rights, particularly the preservation of the freedom of expression, requires irreplaceable involvement of legal practitioners. We play a crucial role in providing both legal advice and advocacy to individuals or groups whose rights have been violated. Like for the case of the Agba that I talked about in Cross River State, some of our lawyers had to go to the street, some had to institute action to call the governor to order. With our extensive knowledge and unwavering dedication to upholding human rights principles, we serve as the unyielding defenders. We lawyers serve as unyielding defenders against any attempt to impede the right to freedom of expression, regardless of the source of such infringement, whether from the president, whether from the governor, whether from the government, anywhere it's coming from. The lawyer as an active participant in the legislative process, we have to be very active in creating laws. We don't need to sit down. Like I always tell people, most of us lawyers, we feel that we shouldn't go into politics. And I don't think that is right. I think we need to go into politics, be voted in as members of House of Reps, House of Senate, as governors, as councillors, as chairmen. With that, we'll have more voice in the system. We'll have more voice in the system. And that is how we can stop this impunity. Although we're discussing yesterday and with some of our colleagues, they said they're always surprised, like when we talk about the sovereign debt issue. you find out that people sign these documents, and it turned out to be that it's mostly lawyers that sign this document, because it's the lawyers that do AG, that they don't know why when people get into government, they automatically change. Even if they were civil rights activists, when they make them AGs or so, they change automatically. But I know that might be a few. There might be some of us that when we take that position, we'll be able to talk, we'll talk truth to power. And I believe we should all, when we go back, the next election coming, please pick a ticket. And I know we will win as lawyers. We have numbers. Maybe when I go back, maybe the next one too, I will pick a ticket. And let me use this opportunity to recognize my teacher of the law school. He's here, and I know that he will also pick a ticket.
Joyce, we'll hold it right there. Our friends, Joyce has painted a picture for us. Come 2024, when we return to a Palu conference, and the entire house is full of their excellencies from the different countries, and we are all speaking the same language of freedom of expression. And she began us off by painting the picture of the fact that all our countries have committed to the international standards. And the big question is, after that commitment, how many of our governments are actually committed to respecting that civic space? Very critical. I want to turn to Professor Joseph. Joyce has shared the implications of these trends for us as legal practitioners or legal practice in Africa. And the big question for you is, then what? Then what for us? And kindly share your thoughts in the view of we are Pan-African Lawyers Union. What do these trends, what do those implications mean for us in legal practice? You have 7 minutes.
Thank you very much, Chair, for the floor. I think I've heard about Florence and Joyce. I think my topic, yes, I will speak on the broader aspect as Spanish, but I would like to touch on the DRC, some response or to compare whatever Joyce has said to the DRC. But expressing my freedom of expression, I will speak in French. Yes, I have 7 minutes. I think I will spend four or 5 minutes. The first one, premièrement.
Joyce, kindly switch off your.
Premièrement, je voudrais faire une quotation. The freedom of expression is guaranteed everywhere. Some of the Constitution, most of the Constitution. But the freedom after expression is not guaranteed. La liberté d'expression, elle est garantie dans toute Constitution, mais c'est la liberté après s'être exprimé qui n'est pas garantie. Parlant de nous, avocats ou juristes, de nous intéresser à la politique, oui, nous devons nous intéresser à la politique pour faire changer les choses. Mais, power corrupt, le pouvoir corrompt. En RDC, chez moi au pays, la plupart des politiciens sont des grands professeurs, des grands avocats, des grands professeurs de droit, la plupart. Et même la plupart des conseillers, des présidents, ils sont avocats ou professeurs. Est-ce pour autant que les choses changent? Le pouvoir corrompt. Faisons en sorte que ce pouvoir ne puisse pas nous corrompre une fois que nous sommes élus. Deuxième point, s'agissant de l'indépendance de la justice, c'est une question fondamentale. On peut avoir tous les beaux textes du monde, les constitutions et tous les droits garantis. Mais quand la justice ou les magistrats dépendent des nominations des politiques, ils ne feront que respecter le mot d'ordre des politiciens et ignorer ce qui est inscrit dans la loi. Même les députés et les parlementaires, ils changent de côté, ils changent de camp selon les intérêts. Donc il ne suffit pas de dire que si nous sommes au Parlement, les choses vont changer. Les choses peuvent changer à mal. C'est le cas dans plusieurs pays, y compris le mien. Qu'est-ce qu'il faut faire en tant que nous, juristes ou avocats, pour faire en sorte que cette liberté d'expression, qu'elle soit pas garantie, mais qu'elle soit une réalité vécue? Joyce a parlé de qu'est-ce que nous devons faire. Je considère ça au niveau interne. Mais au niveau sous-régional, régional ou international, on a besoin de forums comme celui-ci. On a besoin de networks, de réseaux, pour parler à haute voix et mener des actions. Je vous donne un exemple. Même avocat, vous pouvez être arrêté parce que vous défendez le droit lié à la liberté d'expression. Et il y a des cas pareils chez nous. Et localement, les gens ont tellement peur qu'il n'y a pas d'action. C'est juste un communiqué, tout ça. Et là, nous avons besoin, n'est-ce pas, au niveau sous-régional, régional ou international, que nos autres amis, nos autres collègues puissent interagir et aider à ce que la situation change. Et donc, les actions ne doivent pas seulement être au niveau national, mais il faudrait aussi au niveau régional ou international. D'où l'importance des cours sous-régional ou régional. Les ECOWAS, African Court of Human Rights et les autres Eastern Courts, tous les cours, n'est-ce pas, sous-régional sont utiles. Malheureusement, il y aura pour certains cours une question de to exhaust the local remedies. Mais cette question a évolué si on démontre qu'il n'est pas possible de le faire. Et donc, nous devons travailler au niveau local, mais aussi au niveau régional et international. Pour finir sur la question de restriction en RDC, au Congo, en rapport avec la liberté d'expression, la Constitution, en son article 23, dit que la liberté d'expression est garantie. Mais ce n'est pas une liberté sans limite. Parce que j'ai suivi Joyce, c'est seulement, donc il y avait freedom of expression without interference. Mais chez nous, la liberté elle est garantie, mais selon certaines limites. Quelles sont les limites? Le respect de la loi, les bonnes mœurs et l'intérêt public. Oui, vous mettez l'intérêt public. Mais comment définir ces questions de sécurité nationale? Comment définir ces questions d'intérêt public? C'est au gré des vents. Les limitations en matière digitale ou numérique ont été instituées par deux lois, avaient été instituées par deux lois sur la télécommunication. Mais ce que Florence ne sait pas, que depuis 2 mois, nous avons un code du numérique. La FDC a un code du numérique. Et ce code, à son article 360, restreint la liberté de nous exprimer, utilisant, n'est-ce pas, les voies électroniques, ainsi de suite. Je ne dis pas que je suis contre le code du numérique, mais je suis contre l'article 360 qui restreint davantage la liberté d'expression. Et ici, la loi se réfugie derrière la propagation ou la désinformation ou donc il y a l'initiation, initier une nouvelle, une information qui n'est pas vraie, ainsi de suite, sans qu'on puisse définir le contenu. Et en dehors de ça, on met même une sanction. Quelle est l'autorité qui juge que cette information est fausse? Quelle est l'autorité qui juge que telle personne doit être déférée devant la justice? Ainsi de suite. Et donc c'est une question qui tend et qui restreint davantage la liberté d'expression, et principalement à la veille des élections. Je finis pour dire ceci que si la liberté d'expression est garantie dans la plupart de nos constitutions, mais l'exercice de cette liberté n'est pas garanti dans le vécu quotidien, soit par les pratiques de nos gouvernements, ou soit par des restrictions qui sont légales, entre guillemets. Et là, il faudrait voir la question de la proportionnalité. Est-ce proportionnel dans une société, dans un État démocratique, ces limitations-là? En définitive, comme Florence l'a dit, comme Joyce a eu le dire aussi, la liberté d'expression, c'est un droit fondamental. Et il couvre à son cortège plusieurs autres droits. Président de séance, comment ne pas subir la crise de la dette publique? Si nous, citoyens, nous ne pouvons pas nous exprimer, si nous exprimons, le gouvernement pense que nous sommes des opposants ou des voyous qui veulent prendre le pouvoir. C'est une question importante et Palou est mieux placé, surtout dans les pays où on fait des restrictions ou des restrictions en matière d'accès à l'Internet. La RDC, chers confrères, ce n'est pas récemment. C'est depuis 2011, 2016 et même 2019. Donc quand il y a élection ou campagne ou tentative, comment dirais-je, actuellement nous sommes normalement dans 6 mois, nous serons aux élections. Et nous attendons, c'est ça le moment suspect, le moment suspect de la loi, du code du numérique, surtout de l'article 360, pour faire en sorte que les gens ne puissent pas parler, mais nous devons parler ensemble. Le Palou doit, et je suis au courant que le Palou a déjà fait, demander au niveau de la Cour africaine du droit de l'homme et des peuples, avec un avis, quels sont les critères qui peuvent être mis en application par les États pour garantir cette liberté d'expression. Surtout pour ce qui concerne l'accès à l'Internet ou, comment dirais-je, le switch off of Internet. Sur ce, j'ai parlé usant de ma liberté d'expression. Je suis sûr que ma liberté après expression sera garantie par vous. Merci.
Well, Prof. Joseph, you did kick off with a great quotation that the guarantees come before the expression. So we can't guarantee you the freedom after your expression. And he has belabored the point of corruption. And he says power corrupts. Let me also remind him that if you can't beat them, you join them. I now become the devil's advocate for those legal practitioners who have joined them. I like the protests that are coming from the audience that we should never what? We should never join them. Critical question. Who is it that defines this animal called national security in order to limit our expression? Who is it that is going to define this animal called for public order? Before we can start limiting expression, who is it that is going to define public morality before we can start restricting expression? Critical questions that have been put to us. I want now to go to the bigger canon. We want recommendations. We want a way forward. I know in our different practices, there are certain things that we have attempted and they have worked. How can we scale up those initiatives for the better of Africa as a region, but also for the better of the globe? Over to you. Feel free, raise your hand. You'll have 2.5 minutes to share your views on issues raised here, but most importantly, recommendations, best practice. Who goes first? Yes, sir. And then we shall move to the back.
Thank you very much. My name is Isa Choma. I'm from Nigeria. Mine is just a little bit of...
Could you kindly use the microphone for the benefit of the translators?
My own? Thank you. Mine is a little bit of correction, then maybe a recommendation. Joy was emphasizing on electing lawyers represented at the National Assembly or Senate and whatever. That's not the issue. For example, in Nigeria, the chairman of Senate Committee on Judiciary is a lawyer. That committee has about 16, 17 lawyers. The same committee with House of Reps, though it's not headed by a lawyer, but that House of Reps has like 20 lawyers. Other elected senators, governors, ministers, university professors, like he mentioned. It's not because there are no lawyers. The issue is because the lawyers there are not patriotic. I think so. Maybe we need to make them account as professional bodies. I think that's what we should do now. If they go there, they are also our representatives. We have various bar associations. Let's make them accountable. How do you do that? For example, before you inaugurate these national assemblies, invite them, have interaction, do conferences, seminars, induction. Maybe what you can also do is to give them a dinner. After the dinner, you can now talk to them and say, you are accountable, you are all representatives. Give them mandates, A, B, C, D. We expect in the first quarter you should be able to do this. I think that's the way out. Thank you very much.
Thank you so much. As professional bodies, we need now to move to holding our colleagues accountable for their actions, for joining them, simply because they can't beat them. I had a hand at the back. Yes, sir.
Merci beaucoup. Je voudrais parler en français. J'ai 3 points. Le premier, c'est il y a quelques années, l'institut qui s'appelle Katiba au Kenya a commencé une casse. Je ne sais pas ça complète pourquoi, mais au commencement, il y a la question d'accès d'information sur le budget de l'office le cabinet du président. C'était interdit d'accès à l'information, il y a l'affaire qui a commencé et après le résultat, le judiciaire, le tribunal dit il faut donner l'information. Depuis cette affaire, il n'y a pas l'information avec les gens au Kenya, mais on a l'espace dans le tribunal pour demander, et ça, je pense que ça c'est un bon exemple de quelque chose chez nous. Ma deuxième point, c'est quand on commence la conversation, les trois jours derniers, on parle sur professional ethics, les éthiques des avocats. Et je pense qu'on a déjà retourné dans le même point après 3 jours. Il faut développer cette éthique et Palou, c'est une bonne position de faire ça. Mais j'ai quelques questions parce qu'on a beaucoup de problèmes avec la fiscalité. Et je suis un peu préoccupée par 5 choses. Les activités qui sont déroulées dans l'espace numérique, le gouvernement, le business privé, les chambres, tous les gens qui occupaient l'espace numérique pour gagner l'argent. Le deuxième point, il y a les gouvernements africains qui suivi la position de trouver les gens accès à l'information. Mais est-ce qu'il accède l'information fiscale aussi? Est-ce qu'il connaît comment les gens font les choses criminelles, gagner l'argent avec les choses criminelles et aussi les autres? Le quatrième point est comment on traite les flux financiers. Oui, merci beaucoup. Et finalement, il y a le problème de dette. Et il y a beaucoup de gens qui disent que la dette arrive dans un pays et disparaît et il y a le flux financier. Mais est-ce que les systèmes numériques montrent les choses? Est-ce que le gouvernement africain connaît que l'argent n'arrive pas dans le pays? Merci beaucoup. Et pardon pour le français qui n'est pas très bon.
Thank you so much. We have a hand at the back, at the extreme end, and then I will take hers and hers. Okay, please.
Okay, thank you. Brother George, Commissaire Court. Thank you, panelists, for absolutely wonderful presentations, which leave us with an incredible amount of food for thought. I would like to, I'm going to be blunt, I sit on the Commissaire Court, but I've been a lawyer for 45 years, and I've been a member of parliament for 20, 18 of them on the opposition benches. So I've been around the block a few times. One of the major issues that Africa has, and I'm sorry to say this, is hypocrisy. We must move away from being hypocritical. There is too big a gulf between words on a page, what we sign in treaties, in national instruments, etc., and what actually happens. Let us never forget that the Public Order Act, which our British colonial powers gave to us when we were colonies, in order to keep the freedom movements down, were never done away with at independence. In fact, our presidents kept the Public Order Act and used it against their opponents. And this is, I think, the fundamental issue that we have in respect of everything that has a deficit in Africa as a whole. There are incredible success stories. There are wonderful things that can happen. Who is going to make them happen, I think, is the question that we have before us, not only in this session, but throughout the 3 days. Certainly lawyers can help. We have a tremendous capacity for mobilizing action, for taking cases, etc. But the problem with cases is that we have to wait for a case to come to us. We can't go and look for it. So already there we are hampered. Parliament, Joyce says, go to Parliament. Get involved, get elected. That's a very, very good idea, and I commend it to everybody. But how many of us can eventually succeed? And once we succeed, and I'm going to point the finger at myself, for 18 years, when you're sitting on the opposition benches, anything goes. You criticize the government to your heart's content. The moment you get into power, everything that the government does is right, and you have to support it. And this is where the hypocrisy comes in, and we have to be I think, conscious of that. Once we're able to accept that the deficit between what we agree to do by signing a treaty or by writing equality provisions into a constitution do not find reality in daily practice, that is when we need to get up and mobilize. And how can we mobilize? Yes. I think lawyers, and I've been one myself for a long time, I think lawyers are absolute key. People listen to us, we have the intellectual ability, we have the power of the courts, but let us not only rest with what we can do as lawyers. Let us go beyond that. Let us engage with civil society. Let us try getting involved in politics. Because at the end of the day, frankly, as Zambia has shown, if everything depends, unfortunately, on our continent, with the executive. The president in all of our countries, myself included, has got tremendous powers. Can do what he or she likes. Difficult to counter that power. How can we counter it? By changing presidents, by getting more enlightened, younger, liberal people in power. That is the only way forward. I thank you.
Thank you so much. We need to deal with the hypocrisy, but we should never underestimate what we are able to do to cause the change we want to see. Yes, you have 1.5 minutes. You shall give her 1.5 minutes, and then Professor.
Yvonne Brown. I am a solicitor from the United Kingdom where I practice, but I also now live in Jamaica, which is where my parents were born. And I just wanted to make a point in relation to supporting journalists and hypocrisy. I, like many of you, will have been bombarded with the coronation of King Charles. But what you will not have seen, which we saw days after, is that on the day of the coronation, the anti-monarchists, of which there are some, were locked up. They were locked up and released the following day, because it was said that some of their banners could have been used to cause public disorder. And the BBC who like to go around the world and challenge, did not show the anti-monarchists. Yes, the independent BBC, we saw it the day after. They had the footage, but we saw it the day after. So don't let the BBC bring their hypocrisy around the world, and defend independent journalists wherever they are. When the journalists come to us, ask us for advice, how to interpret things, support journalists. That's my little contribution. Thank you.
Wow, thank you so much. We need to expose all the hypocrites across the globe. Yes.
Ok, merci beaucoup. Christine Kamazet, j'appuie l'intervention du professeur qui a parlé du numérique. Ce que je voudrais ajouter, c'est quoi? C'est que pour ce qui est de la RDC, exceptionnellement, la crise politique trouve par moments, la plupart du temps, son gène dans la loi. C'est-à-dire quoi? En RDC, la loi a toujours été source de la crise politique. Pourquoi? Puisque c'est une loi qui a été héritée. Ce n'est pas une loi que le Congolais ont adaptée selon leurs réalités, les réalités locales. Ce sont des lois qui sont venues d'ailleurs. Je ne voudrais pas entrer trop glissé dans cette histoire. Alors, qu'est-ce que je dis? C'est vrai, le professeur venait de parler de la nouvelle loi sur le numérique, mais j'ajoute aussi que dans le même sens, il y a récemment, un ministère, et il le sait bien, un portefeuille qui a été créé sur le numérique. Depuis tout ce temps, la RDC n'a jamais eu un quelconque ministère du numérique. Ça fait deux petits jours que ces ministères existent. Non seulement ces ministères existent, mais la loi aussi arrive à la veille des élections, comme le panéliste venait de le dire. Donc nous nous rendons compte que cette loi n'a pas encore été éprouvée par le temps, par les réalités. Donc ce qui fait que jusque-là, nous n'en connaissons pas encore trop les points faibles et les failles. Au regard de ce que je disais, j'ai parlé sur l'interruption de l'Internet sur toute l'étendue du pays. L'article 360 évoqué par le professeur qui stipule quiconque initie ou relaie une fausse information contre une personne par le biais des réseaux sociaux, des systèmes informatiques, des réseaux de communication, ainsi de suite. Oui, c'est bien vrai que cette loi peut exister, mais est-ce pour autant que cela doit justifier l'interruption de l'Internet sur toute l'étendue du pays? puisque non, la justice existe. Qui enfreint à cette disposition mérite des poursuites judiciaires. Mais ce n'est pas pour autant que vous allez interrompre l'Internet sur toute l'étendue au motif qu'il y a des informations qui doivent être relayées. Donc, pour ce qui est de la RDC, nous avons besoin que cette loi soit confrontée à l'épreuve du temps, et c'est là que nous pourrions connaître ses points faibles et ses points forts. Merci beaucoup, Chéri.
Thank you so much. And friends, the organizers, I have only 3 minutes left because we took more time at the cocktail than we should be taking here. I'll give Florence a minute, give Professor you have a minute, and Joyce a minute to weigh in on the thoughts and recommendations that are coming in from the bigger panel. Joyce, let's begin with Joyce.
Thank you so much, Otto. My final word is that we as lawyers should make our voice heard, call our leaders to order. And with that, we'll be able to have a better world. I know it's not going to be without implication, because if you call the government to order, they will surely come after you. But there are people that have been doing this, and this has really helped us. So we should also continue. And with that, we'll have a better world where we'll have freedom of expression at all times. Thank you.
Thank you so much, Joyce. Yes.
Thank you very much. While we are calling our governments to order, us as lawyers, we also act in good order to be in line with what we're saying. Thank you.
Wow, thank you so much, Prof. Somebody just said, oh. Over to Florence. And Florence, for you, you'll have 2.5 minutes because you're Florence, but you're also ICML, our sponsors for this panel.
Thank you, Arthur, and to everyone for the useful reflections and contributions. Again, just to associate myself with many of the views that have been shared, it is clear that in many of our countries we are grappling with hostile environments and restrictions on civil society's fundamental freedoms and civic space in general. The issue on the role of lawyers in advancing legal reforms is equally pertinent. We have seen a lot of the restrictions are premised on laws, and as lawyers, we have that expertise to guide and influence on legal reforms. As it has already been highlighted, a lot of the laws that are actually being used are colonial hand-downs. Laws on sedition, laws on insults to presidents and other executive officers, laws on criminal defamation. A lot of these are actually laws that need to be reformed outside of the legacies of the constitutional histories that we have all been subject to. And then on the issue of hypocrisy, again, I agree with that. A lot of stakeholders are guilty of this, and I want to also echo our political leaders as part of the issue and the problem. The theme of this conference is sovereignty in Africa. And we know that, of course, these decisions are led by our executive leaders, at the heart of which they are also the sources of corruption, which is causing the mismanagement of these very resources that we are subjecting our countries to. And as such, I agree with everyone who has highlighted the issue of hypocrisy. We should also target accountability of our political leaders. It starts from there before we go to others. And then I also wanted to highlight strategic litigation, as many of you have noted, is an effective and useful tool. It continues to be an advocacy tool to achieve some of the remedies that we are looking at and push back on the restrictions. Beyond that, we need to think as lawyers, how can we actually push for implementation of the decisions that have been progressively addressing these issues? We have seen that increasingly governments are not committed to implementing these decisions, be it from domestic courts, regional or international mechanisms. One of the ways that we have seen that lawyers are looking into is structural interdicts. How can we, again, mobilize action around using such tools to bring accountability where we have seen progressive decisions from different courts and human rights mechanisms? And in conclusion, I just want to also underscore that as we are looking at protecting and pushing back against freedom of expression restrictions, we should also have a clear understanding on the groups that are high at risk of these restrictions. We often have seen opposition candidates, we have seen media, as many of you have highlighted, civil society activists, but now we are also seeing targeted measures against marginalized groups, particularly youth, women, LGBT groups, climate defenders, persons with disabilities. And I also just want to echo that as we are looking for protection mechanisms, these are key groups that we should also look at protecting and working in consonance with them as we push for advocacy against restrictions on freedom of expression and civic space in general. Those are my closing remarks. I thank you, Mr. Moderator.
Thank you so much, Florence. You're now released to return to your bed. And friends, we want to appreciate you so much for your time, for your thoughts, for your reflections. I have a request. Is it a request, Madam Vice President, or it is an order? Madam Vice President says she must have a photograph with everybody that has attended this panel for her record. So she's kindly requesting, please. And right after that photograph, we have 5 minutes for tea, some out there, said that we return for the next panel. Photograph, tea, return in that order. Thank you so much. Have a great day. He's going to advise us on how to do this. You have to hold it. We shall have the group photograph right outside the room.
My lady, please. Okay.
Thank you. Let's go outside. Asante, right?
And we kindly step out of the room for the group photograph. Do not abandon the Vice President. Let's
Of course, the role of African human rights systems in promoting civic space in general. So my name is Nicole Caneza. I'll be your moderator for this session. I'm the Strategic Litigation Manager for Avocats Sans Frontières. And I'll just start. I'm absolutely honored to host this panel of such amazing lawyers, academics, and practitioners to speak about the role of strategic litigation in restoring and protecting civic space. So I'll start with introductions. So I have shortened everyone's bio, so please don't feel discriminated against if I don't mention everything you sent me. Yeah,
So I'll start with Dr. Justice Alfred Mabenzenge. Dr. Justice Alfred is a constitutional and human rights legal scholar and lawyer who is currently working as senior legal advisor at the Africa Judges and Jurists Forum and teaches cyber law and human rights law at the University of Cape Town. He is a senior research fellow for the African LII program of the Democratic Governance and Rights Unit at the University of Cape Town. And previously he worked as senior legal advisor at the International Commission of Jurists, ICJ. So welcome, Dr. Justice.
Are you sure that's me?
I think so. Welcome, welcome. Our next panelist, Arnold Sunga, is an experienced lawyer, human rights defender, and former secretary of the Law Society of Zimbabwe. He has professional experience that spans private and public practice in law. He was a former resident senior director at the National Democratic Institute, NDI, for 3 years in Zimbabwe, and immediate past Africa director at the International Commission of Jurists, ICJ, for 13 years. He sits on a number of boards of international NGOs and has received international recognition for his human rights activism. Arnold has facilitated capacity building of judges and jurists across Africa on administration of justice. Welcome, Arnold. Then we have Chikondi Chijozi, who has been practicing law in Malawi for the past 9 years. She joined the Southern Africa Litigation Center in March 2020, and she's responsible for the Criminal Justice Program. She is based in the Southern Africa Litigation Center Malawi office. Before joining SALC, she worked as the Deputy Executive Director and Litigation Manager for Center for Human Rights Education, Advice, and Assistance. She was also a member of the Malawi Human Rights Commission 7th Board. Welcome, welcome to you. And then finally, Mr. Arthur Jr. Nsereko. Arthur is a Ugandan lawyer and legal scholar. Arthur is currently the Chief Executive Officer and Head of Secretariat at the Network of Public Interest Lawyers in Uganda. NetBill is an umbrella body that brings together individuals, law firms, and non-governmental organizations with a commitment to engage in public interest litigation to achieve social justice in Uganda. Arthur is a member of the Ugandan Law Society Committee on Rule of Law and Strategic Litigation and chairs the Board Advisory Committee on Public Interest Litigation of the Legal Aid Service Providers Network. Arthur is also a member of the East African Law Society and the Global Alliance for Justice Education. Welcome, Arthur. So I want to, start. This is it's a conversation. I think the aim here is to have a just an interactive conversation amongst panelists and participants. So the last presentation was digital freedoms and restrictions across the continent. And we know that the adoption of restrictive and intrusive laws to regulate non-profit organizations, public gatherings and protests have curtailed civil liberties and the role of civil society. In addition, the wide discretion and abusive use of administrative powers by the state in the implementation of laws, as well as the application of disproportionate sanctions, have undermined civil society in many, many ways. And we know that the legal profession has not been spared by these trends, especially those advocates who fight for, advocate for access to justice, who do public interest litigation and human rights advocates. And so there are a vast array of challenges really that often precludes human rights advocates for accessing justice at all. And so I just want to start with just a question. Really, if you could just maybe paint a broad picture of the state of, I'd say, civic space in your respective regions and the challenges that you face as lawyers in protecting civic space before we go into the more specifics of strategic litigation, the role of courts. Anyone can start. Justice, you're sitting next to me, but I'm not. Anyone can start, please. We have a very diverse panel, East Africa, Southern Africa, so please.
I can start. So my experience, I'm just in Malawi, as already introduced, so I have a lot of experience in the military. I've got a lot of experience in the work that we've done in Malawi. And Malawi has also not been spared like other countries when it comes to shrinking the civic space. And the challenges that we've had is also common in terms of laws that are very repressive. In terms of registration of NGOs, there is strict requirement that now NGOs have to be registered with the NGO authority, and there are strict rules in terms of compliance with financial obligations. In itself, by requiring all NGOs to be registered with authority, it means those NGOs that were working in the communities and were working in an informal way cannot operate anymore. And that already creates a problem for people that were beneficiaries of the work that these organizations were doing in the communities, because they cannot operate if they're not registered with the authority itself. Now, in terms of my own experience, I have seen that over time, depending on the issues that are being addressed or the issues that you're trying to bring forward, for example, issues on LGBTIQ, I know it's a problem that is growing in the region with what happened in Uganda, and yesterday we just saw what has happened in Ghana as well, where legislation is being put into place to make sure that issues of LGBTI are no longer, the advocacy around it is being taken back with that kind of legislation. So in Malawi right now, we have a case that is in court on decriminalization of sodomy laws. And the unfortunate part is that the case comes at the time when all these things are happening around the region. And one key issue that I noted is the power that religion has over the civic space. Because in this case, we have over 5 religious organizations, be it Christian, Muslim organizations that have joined the case as an amici and fighting against the case, not just in court, but mobilizing people outside the courtroom, having demonstrations across the country, having radio programs, issuing statements, directing the courts in terms of how they should actually deal with the matter. And in just observing that, it creates a space that is very unsafe, not only for the litigants, but also for the lawyers, because even going to court, you find that people are outside the courtroom chanting songs against the lawyers, targeting, calling out lawyers different names, identifying you with the cause of your clients, calling you that you're either gay or a lesbian, and all of those things coming out because people are writing on the ticket that it is against our religious beliefs. So I feel that as a profession, these are issues that we need to start dealing with, because it seems that religion is one area that, as a profession, we have let it flourish without really looking at how it is impacting on issues of human rights as well as the civic space. And also, another thing is the issue of independence of the judiciary, which has also become a great challenge in terms of fighting for the civic space. In the case that I'm talking about, it is a panel of 3 judges sitting as a constitutional court in the High Court. And one of the judges had to recuse himself based on the fact that previously, before he became a judge, he had written on issues of LGBTI. So the state brought in 6 articles that he had previously written on, and there were also 2 other articles that he had written which were against homosexuality, and the 6 were pro-homosexuality. But then he was actually asked to recuse himself from the case. And when you look at the panel that is handling the case, the other judges are very conservative judges. He's one of the most progressive judges, and he had to recuse himself, and the Chief Justice had to bring another conservative judge to sit on the case. So we have 3 conservative judges dealing with a very controversial issue, and these are very strong Christians, and we have 5 Christian organizations speaking against the issues in and outside of court. That already tells you the space in which we are operating, and it also creates fear among the lawyers. And for you to actually find lawyers who are willing to do this type of work, it's very difficult. So you find that it is the same lawyers that will be working on the issue, and they end up being targeted.
Thank you, Chief Ondi. I don't know if anyone wants to jump in.
Yes. So let me jump in, and thanks to Hunt and the organizers, as well as certain participants who are here, because without our participation, there's really no conference to talk about. And I think Sikon has done a good job, just generally giving the background. But what I wanted to say about civic space in Africa, and civic space is really everything, and I think the justice is usually very good at defining what civic space is for the purpose of our discussion, and I'll schedule over that and ask him to do it. But otherwise, without the ability of communities, individuals, people being able to sit around the table and being able to find what are local issues that they need to grapple with, and being able to hold those who wield power to account for service delivery, for omissions, for commissions, for violations of rights. It's not possible for us to build an African state that we can be proud of. But talking about Africa, especially the post-colonial African state, before the liberation wars, the question of going for the struggle, liberating Africans, creating opportunities for respect for human rights, fundamental freedoms, and being able to create a space that will allow for people to have opportunities that are equal and equitable, that allow them to pursue the best in themselves. That was the real aspiration. But then the post-colonial or the liberation war dividend has not translated itself in a way that is manifest in terms of utilization of civic space to create opportunities for developmental outcomes in our continent. So as a result, I think we're in a very unique type of struggle, almost like a post-colonial African struggle, but some form of struggle within the democratic forces, because we are much better as Africa than where we were in terms of the legal and constitutional and policy frameworks. We have very good African standards on human rights, anchored with the African Charter on Human and People's Rights, and the subsequent standards that have been adopted, including on elections and good governance, the African Charter on democracy, elections and governance. It's an absolutely brilliant piece of overall legislation for Africa that helps, if implemented, to ensure that the liberation struggle can translate into dividend of democracy, open space, opportunities, and developmental outcomes. And then the individual African countries themselves also have very good constitutions and with bills of rights, and some of them very expansive bills of rights which incorporate civil and political rights, economic, social, and cultural rights, as well as group or collective rights on environment, on enjoyment of natural resources and equitable use or access to natural resources in terms of the wealth outcomes. But then, at the level of practice, there's a big gap because we don't see that legislative framework, human rights law framework, constitutional framework, translating into enjoyment of rights on the ground. That's the governance question. That's the human gap, institutional gap in terms of those who are given responsibility in institutions, lawyers, judiciaries, political leaders, being then able to take responsibility for holding public office, to respect, to fulfill, to ensure the protection and promotion of human rights, and therefore creating of that civic space. So on a broad basis, that's what I would say is the legal and constitutional framework. But I work for two institutions, or I'm associated with two institutions. One is Southern Defenders. I see the program manager, Yamanda, here at the corner for Southern Defenders, and then Frontline Defenders. And these two are essentially involved in offering rapid, practical, relevant, and useful support to human rights defenders who face persecution for defending the rights of others and for defending civil space. And Civil Malonga is here because the Open Society is one of those that are very strong at giving support for those mechanisms. So the small grants, sub-grants that they give to human rights defenders facing persecution, you can then analyze to say what are the biggest threats that people who enjoy civic space are facing. What is the biggest threats to civic space rights, if I can put it that way. And one thing that I've seen when I look at the annual report for human rights defenders, Southern Defenders, and Frontline Defenders is that they've categorized the threats, the 5 most common threats that human rights defenders face, which is essentially an attack on civic space. They've said that the top 5 will be arrest and detention. So you can see that arrest and detention of activists, pro-democracy activists, human rights defenders, ordinary people who try to use civic space rights to grapple with issues that affect them. That's a target. The second is generally what they classify as legal action being taken against institutions, against individuals for enjoying fundamental rights and trying to protect human rights. The third is actually physical attacks. So you are trying to be involved in a peaceful protest, they actually deploy disproportionate force to deal with unarmed civilians who are using expression and protest as a means to advocate for change. Then there are death threats that are also reported in the form of application for support that come to these protection mechanisms. And then the fifth one is generally surveillance, that people are actually being surveilled. And I know that we're going to have a meeting tonight with Tulani Maseko's surviving spouse. But one of the things that we receive is that some states have now started using drone surveillance at private residences of human rights defenders. And to imagine a state investing in drone warfare against its own citizens. So these are the areas where protection mechanisms of human space. But then just to conclude, in Zimbabwe where I come from, we've also seen that there is a misuse of international standards that have been developed to try to create the world into a better space and a safer space. For example, the anti-money laundering and countering of terrorism international framework under the Financial Action Task Force. We've seen a promulgation of repressive pieces of legislation to govern NGOs, to govern PVOs, and that in itself is a threat where NGOs are beginning to be equated to entities that spread terrorism, and that's an attack on civic space. So I just wanted to give that background. Thank you.
Thank you. Thank you. That was amazing. Thank you so much, Arnold. And you wanted to jump in justice first, or? Tell us about East Africa and Uganda.
East Africa, Uganda. Friends, whenever we talk about civic space, there are critical questions for us. Am I heard?
Yes.
Yes, right. First of all, does this space exist? Yes. Second question, how large and how safe is this space for everyone? Very critical question. And then the third question is this space guaranteed? That one I will not answer. But one guarantee I can give you is that given the trends shared earlier and the trends shared right here, this space is going to continue shrinking. And for me as a legal practitioner, I say this is opportunity for us to engage. Just imagine if we had a space that was not shrinking, then how would we engage as strategic public interest lawyers? That is my field of practice. And East Africa, the International Center for Non-Profit Law, ICNL, has published 2 studies recently on Uganda and Tanzania. And they speak to civic space, strategic litigation, and civil society organization. Those 2 reports are on their websites. I will invite you to kindly visit their website and have a deep dive into those two studies. But if you look at the 2 countries, like it was said in the earlier discussions, I think it came from Christine, we have this habit of importing law and importing practice. So whatever is happening to your neighbor today, I can guarantee you it is bound to happen in your borders tomorrow. Now I'll go to Uganda. Civil society or the non-governmental organizations are subject to 2 legal frameworks. Before you are registered and licensed as an NGO, you need to first of all register as a company limited by guarantee. And you must comply with all the requirements of a company limited by guarantee. And in place is a regulator. Until that regulator has certified your compliance, you can't move on to the next regulator, who is the non-government organization bureau. Now, even when you get to this bureau, the first thing that you must comply with is a check by the internal security organization. That you as individuals, but also you as an entity who is not yet in existence, are actually safe to operate with. The chances that this internal security will give you a thumbs up, especially when you're going to work on issues governance, human rights, rule of law, and democracy, are that slim. Then you need to find a ministry, a primary ministry, where your activities are going to fall. I'll give you a lived experience of the network of public interest lawyers. Of course, we are speaking law, we are speaking strategic litigation. So inevitably, you must go to the Ministry of Justice and Institutional Affairs. And you want an MOU from this same ministry that you're going to be taking on in this civic space you're speaking to. I will reveal that the ministry rejected our application for an MOU. So what must you creatively do? Find another object that can fit within another ministry. Go to gender and social development and tell them, I'm willing to do community work. And that ministry will give you that MOU, but on an understanding that you're going to do community work. The big question is, does community work involve legal processes, court processes? So at the end of the day, civil society organizations are subject to this dual regulatory process. The company registrar can wake up one day and say, I have revoked your registration. But also the NGO bureau can wake up one day and say, I have revoked your registration, and you cannot Then, we definitely have laws in place. In the earlier discussion, somebody talked about the public order management laws that we inherited from the colonialists. What we are doing is we are smartly amending these laws for convenience. Another lived experience from Uganda. The Public Order Management Act was passed in 2013. In 2015, civil society organizations went to court to challenge the entire law. 2015, 16, 17, 18, 19, 20, 21, no decision has come out of the courts. She talked about the courts. We are talking of petitions that have to touch rights of persons. And decisions are taking 7 years, 9 years. The question is, what is happening to those rights and freedoms in the pendency of that decision? Critical questions we need to put to our courts to deal with. What the courts are doing is they are propagating and perpetrating abuse violations. So, just before this decision is passed in 2021, amendments are fronted. And then a decision comes striking down one section of the law, but then the amendment has passed, and which amendment is not a subject to court's arbitration or adjudication. So what happens? It is a decision in futility. It calls for us to return to court to now challenge this particular amendment. And it has even happened for the Communications Act. Same thing happened just before the decision is passed, challenging sections of the cyber laws. Parliament passes a law, the president assents to the law. Same amendments in relation to a section of the law that is in the court and is being challenged. So the courts annul this old section, but Parliament has passed a new section of the law. In short, we are back to square one. Now, the bar associations. Have the bar associations responded or reacted? East African experience. There is the shared experience of Tanzania, where the state comes and says, we have debarred a president of a bar association. And where does that leave the bar? Where does that leave practice? But somewhat the practice continues in court after our president has been debarred without challenge. Ugandan scenario is where, yes, you will have an executive council of the bar association, but in there are state operatives. And the operating standard in those bar associations is there is no decision that can be taken until it is unanimous. So what all the state needs is one operative on that council, and that operative will defeat any move by the bar association to challenge the state by way of strategic litigation. So we have a space, guarantee it is going to continue to shrink. Prayer is that we do something whenever the space shrinks. Thank you.
Thank you so much, Arthur. Yes, Justice.
Thank you, Chair. I'm very grateful to Balu for the opportunity to participate in this panel. I think the perspective I'm going to share, obviously it's personal, but it's also linked to the work that we do at Africa Judges and Jurists Forum. You must understand, if you see me nervous and a little bit careful about what I'm going to say, because my boss is here, so it's a little bit difficult. Justice Jinoko, who is the chair of our board at Africa Judges and Jurists Forum. I think, before I answer your question about what is the state of civic space in the regions where we work or where we come from, I think it's very important to first have an understanding of what we are talking about when we are saying civic space. I think they are, and I associate myself with all the views that have been shared. So what I just want to do is to try and bring them together so that we have a common understanding of what civic space means. So civic space is basically, I was scribbling some notes here so that I speak carefully in the presence of my boss. The space for individuals and groups to engage with each other, organize each other, and hold the bearers of power accountable. I know that a lot of discussions about holding bearers of public power accountable, but I think we need to go beyond public power, because private power can be sometimes stronger than public power, and even more coercive than public power. I think you know that, and I'm talking to lawyers and serious human rights defenders here. So conceptually, that's what I think is civic space. Now, but at a practical level, what are we talking about? There are certain rights, and Arnold, I think, alluded to some of those things earlier. There are certain rights that are perceived to be important, which must be respected in order for people to have civic space that is open, as my colleague there mentioned, civic space that is guaranteed, and civic space that is accessible. What are these rights? I think most of the material that we read around civic space rights, it will talk about freedom of expression, right to freedom of, right of access to information, right to privacy, freedom of association and assembly. And I think that is correct. But I would like to challenge you to think more, or to think beyond that as well. Because sometimes we can be very elitist in our approach to what civic space is. I think there are some rights that we are not talking about that I think are very, very important for civic space. For example, cultural rights. Cultural rights enable individuals such as artists. Cultural rights enable communities to come together and actually have a space where they discuss not just cultural issues, but social, political, economic issues. I think we all may have a background where we know and we are aware of, platforms such as burial associations. A burial association is there to primarily arrange how one is going to be buried. Yeah? But it actually deals with issues that are beyond the grave. But you might even actually realize that the process or the background to the formation of that burial society began maybe in a church gathering, which means the exercise for religious rights or cultural rights then created the space for people to come up with this burial society. Right? So what I am saying is it is very important to think beyond freedom of expression, right to privacy, and association and assembly. To also think about even the rights of vulnerable groups, like the rights of indigenous groups. Now, it is important to think broadly, because that answers the question, why is civic space important? And my colleagues are right. It's important for purposes of protecting other rights. It's important for purposes of holding power accountable. But it's also important for purposes of ensuring inclusion. Right? So if you go back to the SDGs, you go back to constitutional frameworks that we have in our communities, there is an emphasis around inclusion to ensure that no one is left behind. So we need to create these spaces which empower people to be able to, these groups to be able to organize themselves. And now, what is the state of civic space? And again, I will write on what Arnold has already said. So there is a research that is done by Civicus, and I think they published something called Civic Space Monitor. And I think their methodology could be better, but I think it offers a very solid way of also measuring the state of civic space in Africa or across the globe, but I'm just looking at Africa. So they have a number of categories or indicators. So one of them is open. So they say civic space is open. So civic space is open when a sum total of these rights are accessible and can be enjoyed without any undue consequences. And I think their 2022 report says there are only 2 countries in Africa which can be considered to have an open civic space. The civic space can be obstructed, which means that these rights are guaranteed, as Arthur alluded to earlier on. They are guaranteed in the legal frameworks. Government ministers and presidents, they talk about these rights and they verbally commit to respecting these rights. But then in reality, you see what Arnold talked about, the surveillance that are undue, the arrest, and all forms of persecution for people who exercise those rights. So it means that civic space is obstructed. Right? And I think according to Civicus Monitor, they say 43 countries in Africa have obstructed civic space in 2022. That civic space can be closed, which means that these rights that we're talking about, they are probably not even there guaranteed in the legal framework, or they are guaranteed in the legal framework, but they've been suspended. Right? To the extent that you can't enjoy these rights in any meaningful way. Of course, I mean, you can still express yourself, but maybe there is no freedom after expressing yourself. So practically, it means that freedom of expression is not available. So that's also another way of measuring this. I think we can raise questions around why certain countries are regarded as obstructed and so forth. And we can also question whether it is practically possible to say civic space is totally closed and so forth. But I think from what is practically important for me as an HHF person or rather practitioner, as opposed to an academic, is that we need to think about the individual rights that are guaranteed in the legal framework. But let's go beyond privacy, expression, and association. And think about the vulnerable groups, and think about the spaces they need to, right? And lastly, of course, talking about these spaces, we are talking about, again, because I need to speak carefully in the presence of my boss, I wrote here that these spaces can be online, because we are now living in a digital era. In fact, a lot is happening online than offline. Right? Then it can be physical, so in the sense of physical gatherings. So you can see how those rights relate to those platforms, right? Then the third one is what I'm calling the group platforms. Now, the tendency is to always think about NGOs, CSOs, legal bar associations, and it's perfectly understandable because we are human rights defenders and we are lawyers. But I think we need to also think about business associations. We need to think about trade unions, right? Because without trade unions, without business associations, then the members of those constituencies are not able to gather and organize each other and push for their interests, right? So when we start talking about business interests, business associations, cultural groups, I think we bring in more players into this movement to demonstrate that when we are talking about civic space, we are not just talking about some abstract concept which is of interest to particular elitists or elites, but this is actually something that is very important for everyone, whether a socialist, a communist, and so forth. Thank you very much.
Thank you, Justice, and thank you for your thoughts and for broadening really the definition of civic space and allowing us to think more broadly of what civic space means. Now, you all spoke about the very progressive legal frameworks that we have in our countries, in our region. But you all say that practice doesn't translate on the ground. That the practice of state agents, of authorities, often do not respect these very progressive legal frameworks that we have. And so now I'd like to address, I think, what is the core of this discussion, which is strategic litigation. What is the role of you lawyers, the role of strategic litigation? What are your experiences, successes, and failures? And also, let's think about the role of our regional courts, our sub-regional courts. Are we engaging enough with them? Are we bringing enough complaints before them to create a progressive jurisprudence? I'll leave the floor to anyone who wants to go first.
Okay, maybe this time I will just shoot. I also wanted to do that so that I can build on where I left. So as I answer that question around what is practically speaking, what are our roles as lawyers and human rights defenders in these issues, I think we need to also understand the bigger picture. And now this is what I think we say when we are addressing judges. And I think it's important for us to get this. Because basically we're talking about rights, so there's a clear role for a lawyer and there's a clear role for a judge, right, when these rights are in contention. I think judges often complain about backlogs, right? Backlogs means increased work for them, right? Probably a delay in income for lawyers because the costs are not paid until the matter is finalized. But judges also complain about what is called judicialization of politics, which is basically the idea that political disputes find their way in courts. You know, what is essentially a political dispute is now being resolved through a legal process. Now, if you look at the civic space map, let's just say on Africa, you will see that there's a direct relationship between countries where civic space is obstructed and closed and things like backlogs and things like judicialization of politics. The simple reason is this: when civic space is closed and citizens have no space to hold power accountable, their only way of holding power accountable is through litigation, which is important, but then it creates all these other unintended consequences. So this is the reason why judges, and I'm talking to Justice Chimeko and Justice Tunisile Mamuza, this is why as judges, you need to be interested, they need to be interested in this conversation. So when you talk to your colleagues, I think you can package it that way. That if you want to avoid backlogs, and if you want to avoid judicialization of politics, let us protect those rights that guarantee interaction between citizens and their government, so that they can settle whatever matter that they need to settle there, right? But our role really within the realm of litigation, right? Within the realm of litigation, for me, it is to enforce the certain key legal principles. And maybe that's where the discussion becomes a little bit more technical. I think restrictions on civic space, whether they are online or offline, there's always some kind of a justification, right? But there are norms and standards which must be respected. So in other words, these rights that we're talking about, they are not absolute, they are subject to limitations, which means that restrictions can be permissible. But those restrictions, in order to be permissible, those restrictions must comply with certain principles. And our role as lawyers is to understand those principles, norms and standards, and to apply them when we argue in cases. So one of those is the doctrine of legitimate interest, right? Which basically is the idea that restrictions on these rights, such as privacy, freedom of expression, cultural rights, they are permissible only if they are imposed in order to achieve interests that are legitimate in a democratic society. Right? Therefore, if you impose restrictions in order to then protect the dignity of the president, so you then put a law that says you cannot insult the president, right? Is that a legitimate interest? Interest in terms of regional and international standards? I'm sure also in terms of the constitutional frameworks that we have, right? So that's the first thing you need to look at. The second is you need to look at necessity. Restrictions should only be imposed, or may only be imposed, if they are absolutely necessary, not if they are desirable. So the question is it necessary to impose these restrictions in order to achieve this legitimate interest? Not that it is desirable. So for example, internet shutdowns, they are a form of restrictions on online civic space. The question is, yes, you might want to, your reason might be you are shutting down internet so that you maintain or you restore law and order because there is chaos. But the question is it necessary to do that, right? The question is not, is it desirable? The question is it necessary to do so, right? So, because again, the fact that something is necessary does not mean that it's permissible. You then need to also look at proportionality, right? The idea is you should not use a sledgehammer to crack a nut. You are familiar with all these principles. So the question is, are there other less restrictive mechanisms we could use? I will end there. There are many other legal principles, but I think it's a lot of us here, and I'll give the other opportunity to speak about them, and if they don't, I will come back to that.
Thank you, Arthur.
Thank you so much, and I will take it up from where Arnold has left it. The question is, what are experiences, success, failures, and what is the place of strategic litigation when in issues civic space? We all appreciate the fact that the constitutions have given us those guarantees, constitutional provision, and then our countries come to operationalize the constitution through acts of parliament, in which acts of parliament then we find the restrictions. What is the place for public interest litigation in such a matter? Is for us to go to the courts and tease out all these restrictions in relation to the constitutional guarantees. And then Arnold says judicialization of politics or politicalization of justice. One of our professors in Uganda has written a book, When Courts Do Politics. That is Professor Joe Oloka Onyango. And he says, to begin with, the appointment of judges is politics. There isn't left for countries where judicial appointments are in the public sphere. In countries where judicial appointments are by the executive, you can only access that bench if you are playing the game of the politicians. I'll give an example of Uganda. Our current Chief Justice has a party number, political party number. He sat in the constituency assembly on the card of that political party, returned to parliament on the card of that political party, was a minister under the government of that same political party, and now he is the Chief Justice at the helm of. And then you say, we should never bring politics into courts. But you're already in court as a politician. And therefore the chances that we are going to get justice from you on matters that touch politics, especially if you have a membership where you're coming from, are suspect. And then, what are the chances that you're going to recuse yourself in such a matter simply because there is that traceable interest you have in the matter? And friends, we are at a time where we need to disrupt the status quo until the courts are alive to the fact that we are watching and we won't take it lightly. Disrupt the status quo. Do not allow the courts to dance freely as they believe. There are a number of entrenched procedural practices that the courts are picking on that are not on paper of the law. I'll give an example of granting of bail and then limiting movement within the borders of a country. It has now become an entrenched practice that where you are deemed to wield a lot of political power or influence in the Ugandan borders, you will be arrested, detained, not tried, but granted bail with limitations on how far you can go in as far as Uganda's borders are concerned, including limiting you to only being in the capital city. If you want to leave the capital city, go to court and make an application. How long is it going to take for the courts to grant you that application? Definitely the court will not sit today because you want to travel tomorrow. And then the state is also given an opportunity to come and challenge your application for movement. Now, unfortunately, that particular practice, judicial practice, was not challenged at the time. It was tried out first, and now it has become a precedent. And whoever is deemed political, with a lot of political influence, will be picked, detained, not tried, but granted bail with restriction of movement. And this is where strategic litigation comes in. The other practice that is being entrenched in Uganda is where we have bail, the cash bond bail issues. This is an offense you're charged with, whose penalty is 3 years imprisonment, all, and 6 million shillings. And then you're granted a cash bail of 30 million shillings. The penalty, if found guilty, is 6 million. The cash bond that you're being granted is 30 million shillings. And one of the presidential aspirants in Uganda was slapped with this 30 million shillings. He said, no, I would rather go to return to prison than accept this. The question is, are we as lawyers open and watching these entrenched judicial practices that are not in law that might end up setting precedents, which precedents later on will be written into law? And then we go into the long struggle of challenging that law. And lastly, another example is the question of stay of execution. There is a new practice where the Constitutional Court makes a decision annulling certain acts or certain provisions of a law, and the Attorney General appeals and goes for an application to stay execution of a Constitutional Court decision. Arnold talked about, Justice talked about case backlog. With such an application for stay of execution and an appeal for a constitutional petition, you, as Attorney General, you're going to go and line up behind that case backlog. What are the chances that as the other party, you have an opportunity to challenge this application or even challenge the appeal? That is another practice that is taking root. So, some people say sometimes we are extreme. Yes, we are extreme because the context in which we are operating is not ordinary. Where Attorney General has started applying to state execution of decisions, probably we also need to give them a taste of their medicine. Let us also go into the courts and start applying for stay of execution. The last example, the use of private prosecutions. We've just had an incident in Uganda where practically 3/4 of the cabinet is alleged to have embezzled, misused public funds by taking iron sheets that were meant for this vulnerable indigenous community. And of course, it became a subject of talk for the entire country. The Director of Public Prosecution definitely begins their process, and 2 weeks ago, the Director of Public Prosecution comes and says, I have not found any evidence to warrant the charging of these 17 ministers, speaker, deputy prime minister, vice president. So what do we do? Public strategic litigation? Can't we have spirited people to go and disrupt the status quo and say, well, the same constitution allows me private prosecution, and we are here to privately prosecute the 17. Will we succeed? Definitely not, because we've attempted private prosecution of the highest in the country and they have failed. But they have sent a message to the populace that actually we can stand up and challenge some of these decisions. So, how can we creatively use strategic litigation to challenge these practices that are being entrenched, that might set terrible precedents? That's what it's about. Thank you.
Thank you, Arthur. That was very insightful. Chikonde, I know you wanted to also intervene.
Thank you so much. For me, in terms of my experience with strategic litigation, I think the first thing that I've learned over the years is the timing in which you bring strategic litigation over certain issues. The timing looks at the political context in which you are bringing the issue, as well as also looking at the judges that will be handling the matter. Because sometimes you would have to hold off on taking a case on that particular week because you know the judges that are likely to take up that case that week shouldn't be near that case at all, you know. So those are things that you learn with time. I remember there was a time when we were trying to challenge the criminalization of consensual sex between adults and children. And at that time in Malawi, we were also dealing with issues of termination of pregnancy. The termination of pregnancy bill was in Parliament. So there was a lot of debate on sexuality issues. So we decided to go silently to court and bring an application to challenge criminalization of adolescent sex. And we had applied before the Chief Justice to certify the case as a constitutional matter. So the CJ refused to certify the case because he felt that the law was fine because it was protecting girls from exploitation and all of that. So the way the Chief Justice wrote his notes to explain, because I don't know in other jurisdictions, but in Malawi, the decision on certification of cases as constitutional matter is an administrative function of the Chief Justice. So it's not a judicial decision. So as counsel, you can't really argue before the CJ when exercising those powers. But in this particular case, I couldn't believe it. So I braved up and I went to see the Chief Justice. And I said, yeah, my Lord, I know I'm not supposed to see you, but I can't understand your reasoning why you say the law is there to protect the girl child. And then he tried to explain himself, but it didn't make sense to me, but I just listened. He's the Chief Justice. But 1 year later, we appeared before the same Chief Justice, the same application. He changed his mind. He certified the matter. So for me, it was an understanding that at the time it wasn't good for him to do that because he had all this, you know, pressure from the public on issues of sexuality, and then for him to certify a matter that relates to issues of also adolescent sexuality at the same time, it would have created a lot of, you know, public uproar in that regard. So that's another thing about timing, and that also goes to what we're experiencing in Malawi now. What I talked about earlier on, that we have two cases of one young man who is a trans woman, a trans woman, who was convicted of sodomy laws and is serving 8-year sentence. So for him, he's challenging the sodomy laws, and for him, it's the only way he can get out of the system is to challenge the offense that he was convicted of. Then there's another case. These cases have been consolidated. A Dutch national who was managing a bursary in Malawi and then he was taking advantage of young boys. So there are 8 victims that complained against him that he was sleeping with them in exchange of them getting a bursary from the foundation. So for him, it's a way of avoiding prison and persecution. So when the case that started on decriminalization of sodomy was this one of the Dutch national. And as activists were saying, no, as a strategy in strategic litigation, you need to go to court with the best facts. The facts that will appeal to the public, like if everyone hears the story, will be able to say, why do we have these laws? Even you make the work easier for the judges as well, because you bring in a very controversial legal issue, but then the facts don't speak to each other in terms of the issues and what the facts are about. So this is a clear example of a case where there are allegations of non-consensual sexual relationships, but then the applicant is saying, I want the court to make a determination that in cases where there's consensual sexual relationship between people of the same sex, that should not be criminalized. So in that particular case, as the Southern African Education Center, we had to join the case because we understood that there are bad facts and there's a high likelihood that the court is going to adjudicate and make a decision that will create a very bad precedent on that particular subject matter. So the involvement of our organization in the case was to make sure that we direct the court on the proper issues so that the court is well conversant with the issues and is able to make an appropriate decision. So I'm sharing these cases to show that sometimes the timing and the facts and the issues that we bring to the court can affect the outcome of strategic litigation. And already now we have called upon ourselves all these religious organizations that have joined the case, and there's a lot of pressure. We've had some senior lawyers calling some of us who are advocates to say, you know what, when this court is going to adjudicate in your favor, all of you, we are going to bewitch you and you're all going to die, including the judges and all of that. Yeah, so, you know, it's funny when you hear this coming from lawyers as well. It's like, okay. Yeah, the struggle is real. And the second issue I wanted to talk about was training of judges. It's also something that we need to invest, speaking to Paolo as well, because some of the issues that our judges deal with, they are not well conversant with. And the decisions that come out, they might come out because they have not fully comprehended the issues. I'll give you another example of the case that we did. A woman was convicted of transmitting dangerous disease, something like, I can't recall the actual volume of the legislation, but it was something like that. And the basis on which she was convicted of that offense was because she had breastfed another woman's baby, and when she was HIV positive. So she was given a 7-year sentence. So the case went for review before a high court judge, and prior to the judge sitting on that matter, at Southern African Education Center, we had invited judges to understand issues of HIV transmission and all of that. So she attended the training and she understood that there is actually a very slim chance of a woman to transmit HIV through breastfeeding. So when she understood the science of it, when the matter came before her, she actually overturned the decision and acquitted that woman. So that's a perfect example of how knowledge is very important for our judges in respect to strategic litigation. And that goes on a lot of things that I will educate on. And the other thing that I wanted to share about is how we draft the pleadings is also very crucial, because sometimes as activists we get too excited, we get into the moment of the issue and then we don't really think through the issues that we are asking before the court. So you find that you can get declarations that do not even translate into any change at all. I remember in 2017, the High Court in Malawi had declared the conditions in Malawi prison to amount to torture, cruel and degrading treatment, and ordered the prisons that they should reduce the population of the prison by half within 18 months. But then when you come to think of it, the prisons are on the receiving end. The people that go into prison are people that have been ordered by the courts to go into prison, so they don't really have much to say. So if the particular prison in which the applicants were held, the holding capacity is 900, and at the time there were 1,800 prisoners. And 80% of those were convicted by the courts. So by ordering the prisons to say reduce the population of the prison by half within 18 months, even as much as they want to do it, they can't do it. So the appropriate parties should have been should have been other actors in terms of the orders that were being sought before the court, because in that way you can only get effective remedies if you have the right parties before the court, but also you make sure that there are also some way of structured entities that would ensure that there's enforcement of the court orders, because in that case, 18 months down the line and years after now, the population in prison has even doubled from what it was. So there's no accountability. The court, in the way that the issues were framed, there was no way of following up on that particular orders. And lastly, what I want to speak about is the role of the amici. I think as lawyers, sometimes if we hear this thing happening and we're so invested in that particular issue, we get excited to say we want to be part of the case and join as amici. Like we come from one jurisdiction, we go to another, like, oh, we want to join a case in Malawi, in Zimbabwe. But in terms of the impact that we end up having on that particular case, it can be very detrimental to the parties. I will give an example of the case that I talked about earlier, the adolescent consensual sexual relationships. On the second case that the CJ certified, when court, the case started, and then we had all these international organizations wanting to join the case. So there were like 5 international organizations that joined the case. And before the joining of the amica, the Attorney General was fine with the case. They didn't even oppose the application, because at the time they were already drafting legislation to actually make amendments to the penal code to provide a defense for people who are children and had consensual sex. So when the international amici came in, they felt like there was international pressure. Why are outsiders coming into our space? And immediately the Attorney General challenged the admission, because the court had already admitted the 5 international amici, and the Attorney General filed an application opposing their admission, saying they shouldn't have been admitted, they did not comply with certain legal requirements. And then the court, because the court had invited amici to come on the case, and they had already admitted them, the court denied the Attorney General that application. And what did he do? He did what he was talking about. He went to the Supreme Court, got a stay of the proceedings in the High Court, and went to sleep. He never even filed his appeal. There are no grounds of appeal up to now. He waited until the debate on the amendment was done, and the amendment happened, and the president assented. And the case is still pending in court. As lawyers representing the parties who already argued the case, the only thing that we were waiting was for the court to hear the amici submissions, and then the court makes the determination. So the whole case stood just based on the amici. So sometimes, as lawyers, we also need to strategically think whether we want to join a case or not. And that also brings me to another case. Sorry, I want to say this. A case of a girl who was raped, a 12-year-old girl was raped, and then obviously in Malawi issues of abortion are still criminalized, and the girl wanted to have an abortion. So we sat down as lawyers and said, okay, how do we help this girl? there was a doctor at the public hospital institution who said, within the exceptions of the law in which abortion can be allowed, in this particular case, I can actually give the service to the girl. But the lawyer was like, no, we need to continue this case because it's been hard for us to find a client. This is our perfect case. If she gets the abortion, then what happens to the case? You know, and it had to be a fight among lawyers to say, guys, what are we talking about? This is a human being, and if we wait longer, she will not even get the chance to get that service. And you know, it was the fact that it was a debate in itself, it also creates a problem. So sometimes we find that as activists, our personal interest or the idea of achieving the greater goal of litigation can also affect the interests of the client. So let's always remember that our duty is to the client. You know, there are many ways. Strategic litigation is just one of them, but there are so many ways of still achieving the aim that we want beyond strategic litigation. Thank you.
Thank you so much, Chikondi. Arnold, any thoughts before we take questions? Very briefly, yeah, 5 minutes, because I'm told that we have to finish at 1 p.m. sharp, and we have a speaker online, so I'll let you. Thank you.
Good. In fact, maybe it's more just to give a bit of what I would call an overview, because they've given very good examples, and they've also glorified the role of lawyers in using our technical skills to liberate our communities. But that's exactly where potentially the problem is, because I don't think in organizing a meeting like this, we should be seen as really glorifying the role of lawyers in entrenching freedom and open civic space and democracy. Because I think precisely one of the main drivers of oppression in our societies is actually the lawyers. And they're the ones who draft the pieces of legislation. They're the ones who prosecute. They're the ones who sit as judges and make decisions that really send shockwaves among human rights defenders. And therefore, I think we have to start from the assumption that lawyers are also part of the problem, and that maybe we don't have a critical mass of lawyers that think like this. And therefore, when we meet among ourselves and we're speaking to the converted, we then tend to think we're liberation fighters, and that when we share these things, we can actually get results. And then the question of training, I always hear the question, we need more capacity building, more training of lawyers, of judges. And the assumption there is that judges maybe are not as understanding of the human rights law framework and the constitutional imperatives, and therefore they are genuinely mistaken when they pass those decisions that are so shocking. And yet, in essence, I think a number of them consciously apply themselves to achieve oppressive outcomes because they are part and parcel of the economic and the political class. And therefore the law is an instrument at the hands of those who wield power. I think Justice Masuku from Malawi, from Eswatini, who is now in Namibia, always says that the law should not be like a spider's web that only catches the weak. But in reality, that's actually what happens. And therefore, when the civic space defenders, civic space actors, human rights defenders, legitimate political opponents are trying to be involved about the governance question, about the development question in their own countries, and get targeted, that is not accidental. It's actually a deliberate design of using repressive legislation, repressive instruments, repressive institutions to target specific targets in order to prevent the enjoyment of democratic processes and the enjoyment of civic space and the giving of equal opportunities to our people. This is why I think at the level of designing programming, beyond just getting into specific questions, at the level of designing any intervention by human rights lawyers, we need to be able to say what is driving the gap between standards as adopted, very beautiful standards, and the practices on the ground. There is that gap of implementation of standards. That gap, I think there are two primary factors which you can group into two categories. The first category is where there's absence of commitment on the second could be the one where there's lack of capacity. And therefore, when there's lack of capacity, you say there's commitment, there's political will, but there's incapacity. And that's where the questions of designing capacity building programs, trainings, etc., can become relevant. But you have to ask yourself, which is the main driver between absence of political commitment, political will, and the question of absence of capacity to design proper interventions. But I totally agree that as human rights defenders, lawyers, maybe the most important thing beyond just understanding the use of strategic litigation is to deliberately design programs in partnership with development partners to cultivate and build a critical mass of lawyers who are allergic to injustice. And therefore, through that allergy, they can then be able to say, what can we do to ensure that we move from our aspirations in terms of our constitutions, our views of rights in Africa we want, to real practices on the ground, because that is the missing link. And then, but otherwise, I totally agree that at the level of tweaking, tinkering, yeah, there's more efforts of understanding the principles of necessity, proportionality, legitimacy, the question of debate on do we go for this case or not in this court with this judge or wait for a judge who is right. Those are useful, but I think that necessary are not sufficient. Those were on it. Thank you.
Thank you so much, all of you, for the wonderful conversation. Now I'll turn to, I already see hands up, so we'll take a few questions. I'll say maybe 3 or 4, because we have to, yeah, there's a speaker online. So I'll start with,
yes.
Sir?
Thank you very much.
Maybe you can take a mic.
Oh, yeah. Thank you very much. I am what Justice referred to as his boss. I will ignore that. Right. I think it's very interesting. I want to take myself out of activists. It's very interesting to listen to activists. They talk about strategic litigation. Right? They call this litigation. When the Attorney General and the government lawyers do it the other way, or take a strategic approach to litigation, delays, what and what, is all there. But it's all about strategic. But what I just want to say in defense of my colleagues, it's no need to paint all judges with one brush. Not that I want to be excluded from the rest, but the things in court depend on the law. They depend on the pleadings, like she said, very important. What case have you brought? Now, I just want to ask one question, which came from others, and I think supported by the others. Does civic space exist? Does it? Is a matter of law. What we have are laws to regulate civic organizations, isn't it? Do we have laws which are promotive and protective of civic space? So what we have is regulation. You can't do this, you can't do that, you can't do that, you can't do that. But we don't have like the rights which are conferred by the Constitution of an individual. You have a right to do this. So I think it's a worthy area of investigation. Are we fooling ourselves that there is civic space in legislation? Because you must have legislation which is protective, promotive of civic activity. If it's not there, you deal with other laws. I don't want to go on and on because there are quite a number of issues I would have wanted to raise. But it then comes back to one issue which I think lawyers must be concerned about. What is the role of lawyers, or what role should they play or they play at the stage of lawmaking? Because when the private bill comes up in Zimbabwe, civic society is quiet, no suggestions, no pressure, nothing happens, it passes through parliament, it becomes law. So I think we must be interested to investigate what civic space is provided for in actual legislation. And number two, what is our role in ensuring that at the law-making stage, there is a lot of pressure. There are several other things I would love to talk about, like our colleague from Malawi said, concerning, I think a point she skimmed over, but I think very fundamental. It says we have allowed religion to flourish without investigating its impact on human rights. I think it's a whole area to see how all these things are impacted. Sorry, there are lots of things I wanted to say.
The rest we'll discuss during lunch, but I'll take this side. Yes? You can go ahead. Yes, and then we'll go to the back. Okay.
Thank you very much. My name is Dissenting and I'm from Zimbabwe. First and foremost, I want to appreciate and acknowledge the panelists for a wonderful presentation and discussion session so far. And I want to ask, I would have loved to ask the two judges who are in attendance today directly, but for fear of being held in contempt, maybe I will pose this question to either Justice or Arnold, who relates and associate with our judges closely. I believe through their interactions, they are competent enough to respond to this question. Judges are lawyers, first and foremost. And we are here discussing how lawyers can contribute meaningfully, or the role that lawyers can play in achieving our intended objectives. Through your interactions, gentlemen, with judges, what are some of the challenges that they have faced in the exercise of their functions, in balancing delicately the conflicting interests? On one end, the law, as it is national interests on one hand, and on the other hand, the threats that may exist in light of a national interest and the politics of the day. Thank you.
Thank you so much. We'll take two more questions before the panelists answer. I see one hand up behind. Yes.
Okay, thank you. Good morning. Good morning. Very insightful panelists. Thank you so much. I'll go straight to the point. Okay, better. So my name is Ada Obi Ebuka. I work for the Venn Center. I just have two questions. One, I hear the discussions about bar associations. I know many of them are here. And I also get the sentiment. I'm really wondering on the independence of the bar, because I believe that bar associations really has a big role to play in protecting civic space. What is the missing piece? I hear you talk about politicization of the associations, and we've seen that in many countries. What is that thing that we need to do differently to ensure that the bar rises and be the voice in these issues? That's one. Two, I hear Chikodi's sentiments about amicus and all that, which makes sense. My question then is, what is the role you see international organizations play? Some of us here are from international organizations, international bar associations. Should we help, or should we step back, and at what point, and how do we perceive that? Just two quick questions. Thank you.
Thank you. Thank you very much. We'll take one last question at the back before the panelists answer.
Merci beaucoup. Je me présente. Moi, c'est Maître Philippe Kinyapombo, avocat, inscrit au barreau du Haut-Katanga là-bas, en RDC. Je voudrais en même temps, pour une question que je vais poser, mais essayer de donner un avis préalable avant que je ne puisse poser ma question. L'avis préalable, c'est que nous parlons donc, ici, c'est le panafricanisme. Lorsqu'on voit le panafricanisme, nous voyons tout autour des coutumes qu'il y a eu à l'époque dans nos pays. Nous avons ce qu'on appelait autrefois l'arbre à palabre. Je crois que dans tous les pays d'Afrique, il y avait ce qu'on appelait l'arbre à palabre. Là où on avait l'habitude de régler nos différends. Alors, dans le constat actuel, de part et d'autre, que ce soit du côté de ceux qui disent le droit et de ceux qui font la protection ou le promouvoir ces droits civiques des populations, nous trouvons qu'il y a quelque chose qui frise. Donc, il manque ce civisme-là d'abord dans ces personnes. Donc, les acteurs principaux qui devaient dire le droit est protégé, ces deux acteurs ne sont pas à leur place. À mon humble avis, ils ne sont pas à leur place. Pourquoi? Parce que les avocats viennent faire le chouchou ou encore faire les yeux doux aux juges qui, eux, à leur tour, ne disent pas exactement le droit. Donc, on se pose la question, est-ce que les avocats sont à leur place? Est-ce qu'ils sont à leur place? Parce que déjà, quand un avocat vient pour faire une intervention pour son client, il devait le faire en son âme et conscience. Mais il se retrouve que, même quand les droits de son client ont été bafoués, ils vont passer par d'autres voies. La corruption, par exemple. Et actuellement, les juges ne nous aident plus. Ils n'aident plus les avocats à dire correctement le droit. Ils disent, bon écoutez, je me rappelle, il y a un confrère que nous échangeons qui dit, j'avais un client, on a eu à débattre et tout, nous avons gagné le procès, mais le juge dit, écoutez monsieur l'avocat, pour que votre client soit relaxé ou encore que nous puissions l'acquitter, vous devez payer autant d'argent. Mais cet argent n'a rien à voir avec le droit. Donc, s'il y a le civisme, les premiers qui devaient d'abord commencer à être éduqués d'une manière civique, c'est nous, les avocats, les juges. Et si ces deux partenaires peuvent se regrouper et arranger cette façon de faire-là, je crois que d'un côté, nous aurons réglé le plus grand problème qui est le civisme de la population africaine. Ça, c'est de un. Ça, c'est juste l'avis que j'ai voulu porter. Maintenant, deuxièmement, c'est la question. Ma question s'adresse aux panélistes. Pensez-vous que nous, en tant qu'Africains, on pourra adapter nos lois selon les coutumes de nos pays? Parce que j'ai comme cette impression que tout a été du copier-coller, que rien n'est adapté par rapport à nos coutumes. Et si y a-t-il une possibilité par rapport aux associations de faire une adaptation de nos lois pour que cela puisse essayer d'aider cette population pour laquelle nous sommes des défendeurs? Merci.
Thank you very much. So we have very, very provoking questions. Does civic space exist? The challenges faced by our judges, the role of bar association, and the the last question on ethics and the customs, African customs, which should be integrated in our legal frameworks. Justice, I'll let you go first because you have to.
Yeah, because I have to step outside. So just quickly, I'll answer one question from Blumi, and then you can take it from there. What are the challenges that judges face? I think one is constrained independence in many respects. I think you are, in other words, that's what you sometimes characterize as lack of independence. But I think it's constrained independence because sometimes it's there, sometimes it's not there. And persecution. Persecution is very different from interference with independence of judges because persecution sometimes is done to punish the individual judge for impartiality. That is my answer. I'm happy to engage later, but otherwise, thank you, colleagues. I have to rush for a meeting.
Thank you, Justice.
Yeah.
Thanks.
So I think justice talks about persecution, and it takes many forms. In Swaziland, Tulan was killed, a human rights lawyer, for merely trying to represent public interests. They went to his house and they killed him. And there's no remedy, there's no investigation, impunity. In Swaziland as well, there's a judge, Thomas Masuku. He made a ruling in a case where there had been expropriation of cattle. I think it's 258 cattle that had been taken by people who said they were representatives of the king without a court order. He did a spoliation case, which we all know spoliation, and the judge used a certain language that the king would not have spoken with the forked tongue when he said Swaziland believes in the rule of law. And based on that, he was impeached, and a few other charges were put on him, impeached for disrespecting the king, and he lost his job. And so I think when you are courageous and you have independence, what happens after the exercise of that courage? And I think it inhibits the ability of judges to be truly independent. But the quick answer is the Bangalore principles. They've identified the key principles that must govern judicial conduct. And there are, I think, about 4 or 5 of them. They say independence, impartiality, integrity, propriety, equality, competence, and diligence. But then there's current debate within the judiciary whether another principle should be added, which is courage. Because when you're operating in a certain political context, because the law does not operate in a vacuum, but in a political context, we need courage as a principle. But if you get courageous, what happens? We support each other after courage. Let me just answer the one thing on lawmaking judge. The Southern Defenders have actually produced a model law on human rights defending the question of civic space. And then what they're doing is to try and work with and through civil society in the region to see if there could then be legislation that can be motivated to try and actually do exactly what we're saying in terms of the contribution. Then the final one on bar associations, which is, I think, what the role of bar is at Adiobe. You know, when I was secretary of the Law Society, basically I had said to my team in Harare, Law Society of Zimbabwe, that we've got 3 primary objectives or program areas. The first one is regulation of the legal profession to ensure that lawyers are able to practice law with integrity and protect the public. The second was a representative role, which is basically a trade union role to ring fence the interests of lawyers and operate like a cartel where you prevent other professions from interfering with the work of lawyers, because ultimately that then makes the legal profession profitable. And then the third, which is the public interest law. You know, judges sometimes can't defend themselves when they get attacked by the executive or by other forces. But if the Law Society exercises the public interest law of defending the independence of the judiciary, that's what lawyers should do. Thank you very much.
Thank you. Just before the panelists answer the questions, I'd just like to introduce our online participant who wants to say a few words. Chief Guillermo Canela holds the position of Chief of the Section of Freedom of Expression and Safety of Journalists at UNESCO headquarters in Paris. For 8 years, he held the position of Communication and Information Regional Advisor for Latin America and the Caribbean at UNESCO Montevideo office. During those years, he performed as Regional Coordinator of the UNESCO Initiative for the Promotion of Democracy and Freedom of Expression in Judicial Systems in Latin America. Please help me to welcome him for the intervention. Thank you.
you hear me?
Yes.
I hope you can hear me because I guess we are having some connection problems.
We can hear you.
Great. So thank you so much and greetings from Paris. My name is Guilherme Canella and I'm the head of the Freedom of Expression and Safety of Journalists section. And actually I have been listening, although with some difficulties because of the connection issues, very attentively, not only this panel, but the previous one. And they are very much connected with the key concerns that UNESCO has in terms of the protection and promotion of freedom of expression, access to information, and safety of journalists, which, as you know, are essential for enhancing and fostering civic space, but also, of course, for the previous panel that was more directly connected with this particular issue. Indeed, as was discussed during this panel, there are two things that authoritarian rulers do when they come to power. They reduce the independence of the judiciary and they censor the press. Authoritarians, they don't like independent judges and they don't like independent journalists. So that's why UNESCO has developed for many years now what we call the Judges Initiative, which is a major global program for training judges, prosecutors, and other judicial operators on international standards of freedom of expression, access to information, and safety of journalists. And we have already engaged 32,000 judicial operators from 160 countries. Just as we speak, we are finalizing today a global massive online course with Oxford University, precisely to offer opportunities of capacity building in how judicial operators can actually implement in their decisions or in their prosecution cases international standards that are already agreed by the multilateral institutions and that countries have actually ratified. But that said, of course, the work with judges and prosecutors is just part of this equation. We definitely need to engage very much the lawyers, the others in the legal community in this conversation. And that's why UNESCO, under the Media Freedom Coalition campaign, has created the Global Media Defense Fund. And I understand that a few of our beneficiaries are with you today in this event. I thank very much Paulo, who is also engaged with us in this conversation in many different occasions, and Advocacy Frontiera as well. But today we are launching the fourth call for proposals coming from this Global Media Defense Fund. And this fund has two major areas in terms of the grants we offer. One is for fostering independent journalistic investigations about crimes against journalists or restrictions to press freedom in different countries. So this is one thing, but mainly for organizations or houses undertaking investigative reporting on those cases. And the other big area is precisely media legal defense. And here we are talking about the different organizations supporting the legal defense of journalists and others in different countries, but also strategic litigation before human rights courts or constitutional courts, and so on and so forth. So we encourage you, if you are interested in these issues, to look into our call. You can easily find it, Global Media Defense Fund, UNESCO. The call is open until the 28th of August for receiving projects. We will take decisions until the end of the year for projects to start next year. as you have been discussing in these two previous panels, we are particularly concerned with the legal harassment of journalists and other users of freedom of expression. In many countries, this phenomenon that is known as strategic lawsuits against public participation is a growing, unfortunately, phenomenon, and therefore we do need lawyers to face this problem, either defending those that are being unjustly bringing to court with this, but also putting forward strategic litigation cases, trying to stop these kind of processes. But we still see the usual misuse of defamation laws, not aligned with international freedom of expression standards. We still use a lot of what we call indirect censorship, like suing media houses for tax issues, or accusations or false accusations of money laundering, all sorts of different excuses to, at the end of the day, restrict freedom of expression. So I don't want to be between you and your lunch, so it's just to reinforce this invitation for all the interested organizations to apply to this force call of the Global Media Defense Fund. I thank very much Paulo and Advocates Sans Frontières for the invitation to be with you. Unfortunately, I couldn't be with you lively in Victoria Falls, but please keep counting with UNESCO to support the fantastic work you are doing. This is a central issue for keep protecting human rights across the border, to which freedom of expression and access to information are particularly relevant enablers. So thank you so much.
Thank you very much, Mr. Canela, and I think everyone has noted the Global Media Defense Funds, UNESCO, is waiting for your applications before the deadline. So I really encourage everyone to just, to continue this conversation outside during lunch. I was just communicated some housekeeping announcements. One, not to forget to register for the gala dinner and to pay the fee. Second, registrations of new members is ongoing. If you want to register, and there are still pictures being taken for membership IDs. Yeah, those are the last announcements I'll give. And please, let's continue the conversation outside, because two of our panelists were not able to express themselves to answer the last questions. But thank you all very, very much, and thank you to the panelists. Wonderful. Thank you all.
I wanted to answer your question on the role of the amicus. I don't believe that if you believe that you should that you must, the amicus must never step back. Because you know what, it also attracts other amicus, and the thing is you guys can join together. In the South African context, I believe the amicus has played a phenomenal role in stimulating debate. So from a South African perspective, I can tell you don't step back. Okay, love.
I hope you remember me. A while back, I had called you for a meeting.
So anyone who calls my number from here, they automatically start following that number.
Oh, I guess that's the same person. Yeah. How are you? Yeah, but this is doing better now. No, it's not too late. So, we moved within 2 years.
The challenges of eating those kinds of
Yeah. Anyway, I'll see you around.
All right.
So it will be that you need international or regional understanding issue and get international to research it and give you so you are clients, how many clients. So you mean international law, you explain what you want and then they have an institution and then you use it to do it. So that way, it's my own way of thinking of advice support. They're different. Is it legal? Oh, yeah.
We'll keep in touch, definitely. Keep in touch. And I'm going to also introduce you to some of the other lawyers that are regional statutes of the okay. And also the president of the membership of the law. So a lot of lawyers I just have my okay. I think the first